If it has been challenged, then there's
it's all done. Then I don't have a case.
If it has been challenged and that amendment has been upheld, then you don't have to file an amendment.
That's what.
Please find out. I think you can consult Mr. Budhadev Rautai.
I'll consult him. Actually, I was talking to Samvidas. He said that no, I have not challenged it.
No.
I'll talk to my land senior Mr.
Is this matter on 7th May, as prayed for by Sri Das.
Matters items 7.
Yes.
I pray let become any day in the first week of May. I have taken the consent of Mr. Park.
It's a part-third matter.
It's a part-third matter. The Lordship on the last occasion had directed my learned friend to produce the records of appointment of the petitioner as well as the.
Yes, I will produce the records because the difficulty is the leg of the principal has been broken. So he will come by any means that will be present here. And we will produce the records.
Let it continue as part-third, your Lordship. Keep it on the 6th.
All right. Sri.
Let me give 6th.
Sri D. Patnaik and counsel appearing for the opposite party requests for an adjournment. It is this matter on 7th April.
Item 15, my lord. Can it be taken up at 2 p.m. also?
I can't say that because 2 p.m. we have other matters also.
Okay.
We'll see. Adjust.
Item
If it is unable to be concluded, it may be taken up.
Item 15, my lord.
7th.
Item 15. Item 15, my lord. Mr. Sashikanta Mishra, father expired, my lord. Prefer 2 weeks, sir.
Item 15, yes, what happened?
Mr. Sashikanta Mishra, father expired, my lord. 2 weeks time.
Therefore, adjournment is made on behalf of Mr. Sujokanta Devadi, whose father has expired. Let this matter 2 weeks for 14th May.
Item 8. I think it's a part-third matter.
Yes.
I have some personal problem.
No, where is the other side?
Just Mr. Author is there.
They ask it.
I will intimate him.
No. This is a 2012 matter, Mr.
No,
Das.
it is not. No, since it is a part-third matter.
So it's also, as you said, it's a part-third matter. So, where is Mr. Author? You call him, then I will say. Yes.
To go to Anganwadi to attend the post-death ceremony of my brother-in-law.
Yes.
To set pay.
No, but unless you take his, taking his consent, it will be a part-third matter.
Yes.
नहीं अपन ताको पहुंचे जितने बेटर होता था अपन कॉल आगे ताको कोई इन्फॉर्म करी था अपन मेंशन करते बोले था सिंस इट्स अ पार्ट मैटर
अब असली पहुंचली तो केंद्र अपन इसी पे बात ली पार्ट मैटर बोले
और लेट्स से अमिताभ बच्चन काउंसिल अपेयरेंस से ऑपोजिट पार्टी आया
आई एम रेडी आई एम स्पेशल में कर दे पड़ी
नो ही इज नॉट देयर ही मे नॉट बी रेडी
पूरा खोजली पाइले
कौन है request for an adjournment on the ground of his personal difficulty. Leaves this matter on 30th April. Yes.
This hearing was concluded and judgment was reserved. My lord, I am filing written note of.
Yes.
Matter of 2012. It's a Anganwadi matter. There is interim order, but no one is posted in that case. It keep there.
Yeah.
And another matter, item number 22.
First week.
After that, I will auction. The first week come.
All right, 7th May.
Well, it's a fresh second of it. Next week, any days.
Regular. Supplementary item number 1. This is a second appeal against confirming judgments. The defendant numbers 2 and 3 are the appellants. Now the suit was with CD memorandum. Who are respondent number? 2 and 3. Defendant numbers 2 and 3. Okay. Are the appellant? Now it is against confirming judgments. Yes. The original suit was only for permanent injunction, along with ancillary reliefs of cost and other general reliefs. There was no prayer for declaration of title. Now it is maintainable. It would be maintainable, but what I mean, there's a decision of this court directly on this part. We have it would be maintainable. Or Justice G.B. Patang, I'm forgetting. It would be maintainable, but the question is the source for injunction simpliciter is maintainable. Maintainable. Yes, anyway. But they have gone into questions of title and have found that the plaintiff has title, we don't have title. So whether that is permissible or not is one question. But madam, you see page 30. What basis you were possessing the property? We were possessing the property on the basis of the defendants on the basis of the ROAs given by, in our favor by the government. Now, those documents, exhibit B, C, D up to J, those have been completely ignored by the courts below. What they have gone by is the plaintiff's case that the land was acquired by the government, and since they have title, they are in possession, and accordingly it has been decided. So if my lord would see running page 30
Yes.
of the lower appellate court's judgment,
No, let us first see the trial court judgment.
my lord,
There are how many? Eight issues.
my lords.
He has framed the issue regarding, it depends on what you would have pleaded in your written statement.
My lords.
You may have raised the question of title. You are the defendant.
We are the defendants.
So you may have raised that question also.
The entire tenor of both the judgments is as if the defendants don't have title and hence the suit is decreed.
No, I want to ask you, that will be, we will know after calling for the LCR. What was your pleading? Because it is mentioned in the issue, there's a specific issue has been framed regarding title. So probably you would have contested the title of the plaintiff,
But then,
saying that he doesn't have title.
but my lord knows that it is the plaintiff to establish his own case.
That's true, that is true, that is true. So once you raise the question of, because it is, it is intricately linked.
My lord,
Though a suit is simpliciter is maintainable, but it is intricately linked to the title.
my lord. Now, my lord may kindly see the issues are at page 62,
Yes,
page 61.
I've seen the issue, yes.
Now, what would be important would be also issue number 8, because this was one specific issue which was formulated by the earlier appellate court, where the findings have attained finality. The earlier title appeal, the court said that you frame a specific issue, that is issue number 8 at page 61, whether the land was remanded. It was remanded.
Yes.
And after remand, the court below takes up the issues. My lord may see page 62, issue numbers 2 to 8. All together they take. And the entire discussion is regarding the defendant's case. If my lord would see.
Yes, then,
And this specific issue also has not been answered, which was on the basis of which it was remanded, that has not been answered. And then my lord may kindly see the lower appellate court, what the lower appellate court holds. That would be at page 41. Paragraph 10. The
Yes.
court formulates that these are the 11 questions for the appellate court.
yes,
And just prior to that, if my lord would see page 37, paragraph 8,
Yeah.
our specific contentions are recorded. I'm just placing para 8 from page 37.
yes,
That is internal page 14 of the lower appellate court's judgment. Being aggrieved, the defendant appellants prefer the appeal on. Now all our grounds are recorded. One specific learned lower court has discussed only 2 issues. Finding is not supported by evidence. Then earlier lower appellate court judgment not considered. Now all these contentions are recorded, but they have not been answered in any manner. So 8 and 9, our contentions are recorded. What would be most important would be exhibits A to P at page 40. Prove that the appellants have title, interest and possession over the suit lands and preparation of ROR in the name of vendors of the appellants and the ROR in the name of others. So this was for injunction simpliciter. Now these documents are all completely ignored. 8 and 9 are contentions are recorded. Then my lord may see the findings.
then what did you say? How did you come over the property?
we said that the plaintiff's father had sold the land to Narayan Biswai, and thereafter Narayan Biswai had sent to sold to Daswati Sahu, and thereafter we were the purchasers.
From Daswati Sahu. The RSD was exhibited.
Yes, and apart from that, my lord, may kindly see the manner in which this is adjudicated, my lords. All our contentions are recorded. 11 issues are formulated. Para 11, all issues are taken up simultaneously, and then my lord may kindly see how it is answered. Para 12, page 45. Now, in order to ascertain if actually the suit land has been acquired by government or not, the case record reveals the map of so and so, award in so and so. Now, the government has acquired some part as per list. The land of Narayan Biswai extending to 0.06 cent is included in the list of lands which was acquired by the government. Hence, from the above, that the documents reveal that the lands purchased by Narayan Biswai under a registered sale deed has been acquired by the government.
Just a moment. So this is a purely a factual finding.
My lords.
What is your response to this?
Now, if this land was acquired by the government, then exhibits A to P settle the land in favor of my clients. How could they come into existence? So if the land was acquired, then how could we continue?
That since the land was acquired, this your vendor Narayan Biswai did not have title. Your vendor is not Narayan Biswai, somebody else.
No, then Daswati Sahu. His vendors didn't have title. Now the question is, it was for the plaintiff to show it's a suit for permanent injunction. So far as our case is concerned, we are coming with government documents saying that we are paying ROR. Those orders have been finally. Those documents are ignored completely. Now, my lord may see, our documents are completely ignored. I was placing from page 45.
Yes.
Hence, from the above documents reveal that the lands purchased are registered so and so. In the context of exhibits 8 to 9, it appears that the land sold by has acquired. Hence, Narayan Biswai or any other private person has got no title, interest over the suit land as has already been acquired by the government. Now, when the plaintiff submits that Narayan Biswai sold the land to Daswati Sahu, there the defendant contended had not sold the land and possessed the same till so and so. His wife gifted the same to his grandson Biswajit Patra, who mutated the same in his name and subsequently executed a special power of attorney in favor of father of so and so. So now the discussion of the defendant's case happens entirely. And para 13, they hold the defendants have no title. Then only on the basis of the plaintiff's oral evidence and the survey knowing commissioner's report, this has been decreed. Para 14.
All right. So what is the substantial question of law here? What are you framed? Are you framed any?
Yes, my lord. We have framed and we have taken specific grounds. One is page 14, ground number D.
Have you framed it in a question form?
Yes, yes.
Where is it?
The questions are from page 21. That particular ground would be at page 22, ground number 7. This is also backed by a number of judgments which we have mentioned in page 14, ground number D. There are 3 Supreme Court judgments. This is well settled that you have to basically the plaintiff has to stand on its own legs. So the question would be at page number 7, page 22, ground numbers small Roman 7, and the judgments supporting that are at page 40.
Heard Sri Gautam Mishra, Learned Senior Counsel with
Asim Das.
Asim Das, Learned Counsel for the appellant. Produce the impugned judgment, as also the judgment of the trial court. Considering the findings and the grounds taken in the second appeal, the same is admitted on the following substantial question of law. Look, one. Whether the courts below committed material illegality in harping upon the so-called weaknesses of the defendant's case to decree the suit in favor of the plaintiff. That's all. Issue notice by registered post with AD, returnable within 4 weeks, requisites be filed within 3 working days. Stop. Para. LCR be called for. List this matter on
25th June.
25th June. Yes, great.
Item number 2.
May I please, your lordship? The matrimonial appeal, your lordship. The
Matrimonial appeal, the
suit was tried by the London civil judge senior division, and appeal has been preferred dishonorable court. And dishonorable court under Annexure 2 opined that it should be an appeal before the London additional district judge.
Yes.
For that reason, I have preferred an appeal before the additional district judge, and additional district judge refused to condoning the delay and dismissing.
That's all right. That's all right. But further appeal, second appeal is maintainable before this court.
It is a second appeal under 96.
No, that is what I'm asking. Whether it is under 96.
100, your lordship. It's
I mean 100. Yes. How come it will be treated as an appeal under 100? Because you have invoked the Family Courts Act in filing. You must have invoked the Family Courts Act while preferring an appeal. Mata.
I have invoked that. That is invoked.
Family Courts Act. Please examine this.
Yes, your lord.
Just please examine this.
Yes, your lord.
I'm not very sure whether what is the SR किसी कोई ना.
Lordship, Annexure 2 kindly have a glance.
Yes, yes. Annexure 2 is the matter.
Matter. And the land, this honorable court none appears from the side of the appellant. And opined that accordingly matter is allowed to withdraw.
So once matter is again you preferred another appeal before the
additional
decision. What is that? That is also matter.
That is numbered as matrimonial.
So this court in family matters or matrimonial matters has the jurisdiction in the form of matter
Yeah.
against the order of the family court.
Family court. Yeah.
So family court and the additional decisions are of the same cadre.
Yes.
So see the matter to decide kole. It came to This is my doubt. Please examine it.
I will examine it.
I may be wrong also, but you examine. List this matter next week. Learned counsel for the petitioners shall address the court as regards maintainability of the appeal. Yes.
Item number 3. Yes, sir.
Serial MCQ test lo mo.
May I please, your lordship?
Serial MCQ po issue.
Same prayer, same.
Yes, what is this?
Your lordship, this is a CLMC with the prayer to quash the FIR dated 6/11/2022.
Why?
Your lordship, the brief fact of the case is that as per the complainant, the father of the petitioner was watering his land when the petitioner out of nowhere abused him with filthy languages, then used a sharp object to attack on the head of the father of the complainant. Your lordship, thereafter, your lordship may kindly turn to page 14, which is the FIR. It has been stated in the last paragraph that Prakash thau ki Mendhasala CHC re bapanko mundare 7ଟି stitch ପଡିବା ସହ ପ୍ରାଥମିକ ଚିକିତ୍ସା କରାଯାଇଥିଲା. Your lordship, thereafter, your lordship, the petitioner had applied for anticipatory bail before this honorable court, wherein a condition was stipulated that if the injury report is not grievous, then he may be allowed on bail. Thereafter, the petitioner approached the court below, and a false injury report was submitted by the prosecution, your lordship.
False.
Your lordship, that was the apprehension of the
By the prosecution. False injury report.
Your lordship, that was the apprehension of this petitioner, because of which this petitioner had approached this honorable court via CRLMC, your lordship, wherein your lordship had granted liberty to present the same by filing a modification in the anticipatory bail register on the alleged date, your lordship. So, your lordship, the petitioner, my case is, your lordship, whenever there is no evidence of injury, your lordship, then the offences of section 307 and 323 are not being made out. And your lordship, since the date of occurrence, your lordship, the charge sheet has also not been submitted, neither final form has been made. Your lordship, the entire allegation is false and it is an exaggerated FIR, your lordship. And on that ground, I am...
Where is that false report, injury report?
Your Lordship, it was submitted in the court below, Your Lordship.
Yes, you don't have a copy of it.
No, Your Lordship.
Then how can you say that it is false?
Your Lordship, I have instruction that it was submitted, and later when I tried to obtain the same through RTI, I was told that no such patient was ever registered in the CHC on the.
Raise that plea before the court below. Why come to the High Court now? You can very well raise this plea.
Your Lordship, but when there is no, Your Lordship.
I'm asking you, supposing there is no injury, but there is evidence that somebody had attempted to assault somebody with maybe with the intention of killing him or otherwise. So will 307 not be made out only because there is no injury? I'm asking you. What does 307 say? Please read. Where's the book? IPC. IPC ଆଣିନାହାନ୍ତି? IPC ତ ଆଣିନାହାନ୍ତି କେମିତି ଆପଣ ସାର୍ ଇଏ କରୁଛନ୍ତି? 307 ପଢନ୍ତୁ।
Attempt to murder. Whoever does any act with such intention or knowledge and under such circumstances that if he by that act cause death, he would be guilty of murder, shall be punished with imprisonment.
Well, ଛାଡ଼ନ୍ତୁ. So whoever does any act, first there has to be an act with such intention or knowledge. There are two things. And under such circumstances, that if he by that act caused death, he would be guilty of murder. So there has to be, there's a explanation, there's a illustration B. A with the intention of causing the death of a child of tender years, expose it in a desert place. खरार से छोटा मर गया. Injury not so.
But Your Lordship, prima facie, there is no evidence of any act also done by the petitioner.
This is what he says. And let the charge sheet be submitted. We'll see. ମୁଣ୍ଡରେ ଉଦ୍ଧାର କରି ଏକୁଟିଆ ଥିବାର ସୁଯୋଗ ଦେଖି ମୁଣ୍ଡକୁ ଗୋଟେ ପରେ ଗୋଟେ ଛୋଟ ମାରି ଚାଲିଲା।
It's only allegation, Your Lordship.
It is obviously it's an allegation. Nobody is saying that you are guilty.
And my only case is that it's an entirely exaggerated allegation, Your Lordship.
Could be.
Devoid of any.
You are on anticipatory bail.
No, Your Lordship.
Then yes, that is what the previous
Anticipatory bail, then my lord CRL was filed 2424 of 23.
Yes. No, that was withdrawn with liberty to seek modification. Also passed by this court on ABL number 152. Did you obtain that modification? Did you get it modified?
No, Your Lordship,
Right?
that was rejected because
That was rejected. All right. That was
at that
rejected.
time this RTI report was not there, Your Lordship.
Yes.
It was only on.
You raise this point at the appropriate time before the court below.
Your Lordship, if Your Lordship may call for the CD, Your Lordship can also.
Charge sheet दिया ही नहीं. Why are you so worried? Let the charge sheet be. Charge sheet may not be submitted. How do you know? Charge sheet will be submitted since this 307 may not be there. Also may be dropped. How do you know? The entire case may end up in a final report.
It has been more than 1 year and 6 months, Your Lordship.
True.
Charge sheet is not being.
Yes, this delay itself shows that there is no evidence against you. So the police may not submit charge sheet also. Police may submit a final report.
On that ground, Your Lordship.
So you simply withdraw it with liberty to move after a charge sheet, if at all, if charge sheet is submitted. And thereafter, you can also obtain an order to renew or to raise all these grounds at the time of or to seek discharge also at the appropriate time. You can raise this. These points, factual aspects, are not to be gone into by the 482 court.
No, Your Lordship, my submission is that prima facie there is absolutely nothing on record.
There is one. You are yourself saying that there is one injury report, and there is one document saying that nobody was treated at that hospital.
Yes.
So this is a factual dispute which is to be decided by the court below, not by the 482 court. 482 court will exercise its jurisdiction when there is everything is apparent on the face of it. When even accepting the prosecution as correct, no case is made out. In such a case only, what is the leading decision for quashing? Assaulted the father of the informant by means of a sharp cutting weapon after chasing him for some distance and abusing him. Stop. As a result, the injured sustained grievous injuries on his head, for which for which the wound had to be had to be given 7 stitches in the primary in the CHC actually in the CHC, community health center. Then counsel for the petitioner submits. What's your good name?
Jacqueline Jenna, Your Lordship.
Your name?
My name,
Yes.
Jacqueline Jenna, Your Lordship.
Miss Jacqueline Jenna. What is the spelling?
JACQUILINE.
Hello, have a look. Miss Jacqueline Jenna, learned counsel for the petitioner, submits that the allegations are on the face of it unbelievable and in any case are exaggerated. She further submits that the prosecution has produced an injury report in the court below, which according to her is forged in view of the information obtained by her from the CHC under the RTI Act to the effect that no person named as the injured was ever admitted or treated at the center. Stop. This, according to Ms. Jana, proves the falsity of the prosecution case as laid, and therefore this court should interfere. Learned State Counsel has opposed the contentions raised by Ms. Jana by submitting that the application has been filed at has been filed prematurely as investigation is still in progress. The contentions, the charge sheet not having been submitted, it is not desirable to interfere at this stage. Stop. He further submits that as regards the contentions advanced regarding the injury report or absence of injuries, Sri Mishra submits that these are factual disputes which can only be gone into by the court below at the time of trial. So, after hearing counsel for the parties and on perusal of the FIR, as also the information obtained under the RTI Act by the petitioner, this court is of the view that the investigation being in progress, it would be premature for this court to take a definite view at this stage that the prosecution case as laid is not made out. Stop. It is for the contentions raised by the petitioner can also be considered by the investigating agency. The CRLMC, therefore, I am not inclined to interfere in the matter at this stage. Stop. The CRLMC is however disposed of, granting liberty to the petitioner to apprise the IO appropriately by furnishing the document obtained by him from the concerned CHC under the RTI Act. Stop. If such said document is produced before the IO within 2 weeks from today, the same shall be considered.
Right.
Same shall be considered on its own merit. Yes.
Much obliged.
Item 4.
Body authority
Please, Your Lordship.
and 482 color, the first thing that you are required to do is to first to make a small research. What is the law? What is the scope of interference by the High Court under 482? Because no other court has that power except the High Court. Now, what circumstances 482? So you should read that judgment, and you should also, Yes, true. You are factually very thorough and I appreciate it. But you should also know the law. 307 ingredients gone. 482 Bhajan Lal kon କହିଛନ୍ତି, what are the leading decisions? How they have been interpreted? Yes.
My lord, here the petitioner is the husband and the marriage was solemnized on 10/5/23 as per Hindu custom. After that, they will live in a happy marital. Then after the wife, without any consent to her husband and his mother-in-law, go to her in-laws house. Then after file a FIR against the petitioner under section
You want transfer of which case?
CRLP number 45 of 24 pending before.
Filed by the wife
Yes, ma'am.
for divorce. CRLP means
On
maintenance
for maintenance.
yes,
ma'am.
maintenance. So 125.
Yes, madam.
You want it to be transferred from Khordha to
Cut.
on what ground?
My lord, here the petitioner mother is the widow and they they live in a rented house
So
and threatened by the opposite party also, the petitioner.
so if you are threatened by them, report it to police. Report it to police. Why do you want it to be transferred? Tell what are the grounds for transfer?
My lord, only that ground threatened by the petitioner opposite party, man.
Your wife threatens you.
Yeah, not my wife, family member.
Why family members are threatening?
Yes, madam.
So there is a court. Approach the court. Approach the court below for protection or inform the police. Why transfer of the case? Yes.
My lord, is a labor in person and from Khordha, they are.
He can appear virtually also if he wants. If he wants, he can appear virtually from Kendrapada itself. He is staying in Kendrapada,
Yes, madam.
isn't it? No, look at Kendrapada. At present, Sashikanta Mishra rent house, Nuasai, Swami Mandir Lane, Chaudhar or district cutout. Where are you exactly staying? Kendrapada, Chaudhar or Chaudhar?
Chaudhar, my lord.
Chaudhar. So Chaudhar, he can appear virtually also, wherever he wants. The petitioner, husband, seeks transfer of CRLP number 45 of 2024 from the Court of Learned Judge, Family Court Khordha to Learned Judge, Family Court Cuttack, filed by the opposite party wife seeking maintenance under section 125 of CRPC. It is submitted that the petitioner has been residing at Chaudhar, being a mason. Stop. He earns rupees 400 to 500 per day, whereas his wife is earning rupees 75,000 per month. What is she doing?
My lord, not instructed.
Huh?
I don't know, my lord.
You don't know, but you have mentioned it in your
In
in paragraph 6.
yes, my lord.
The opposite party claiming that the acha, ठीक है जी. So 400 to 500 rupees per day. सेतिकी है ना? Further, the petitioner is residing with his widowed mother in a rented house, and he has received threats from the family members of his wife. Stop. For all these reasons, apprehending danger to his life, he wants the proceeding to be transferred to Cuttack. Full stop. After hearing learned counsel for the petitioner and on going through the transfer petition, particularly the grounds raised therein, I am not convinced that this is a fit case for transfer of the proceeding. Stop. The plea regarding intimidation / threat by the family members of the opposite party wife appears to be vague and non-specific. In any case, if the petitioner has any apprehension, he can approach the police or bring it to the notice of the court below. That apart, the petitioner can also appear through virtual mode. by obtaining necessary permission from the court. Since the opposite party wife, being a permanent resident of Kendrapada district, is presently residing within the territorial jurisdiction of the family court at Khurda, it would be proper if the proceedings continue to be held at Khurda. So, for the foregoing reasons, therefore, I am not inclined to allow the prayer for transfer, which is therefore dismissed. It shall, however, be open to the petitioner to seek necessary permission from the court below to appear through virtual mode. If such application is moved, the court below shall consider the same in accordance with law. Yes.
Paragraph 5.
May I please your lordship. The present petitioner is the wife of the opposite party. This petition is filed for seeking of transfer from the Judge Family Court Jajpur to Judge Family Court Kendrapada, your lordship.
Why?
The civil proceeding filed by the husband before the Judge Family Court Jajpur under Section 9 of the Hindu Marriage Act for restitution of conjugal life. The marriage was held on 24th February.
You are not willing to stay with your husband?
No, my lord, because FIR has been lodged before the Hon'Ble police station on 10th April 2024, your lordship.
It's a Section 9 application.
Yes, my lord.
What FIR?
FIR I have not annexed.
What FIR? Why?
No, FIR thereafter, after filing this.
So, FIR has been lodged at Kendrapada. So this
So
case
the
also has to
police
be
station-
transferred.
Yes,
This
my
case also has to be transferred. Because this case will.
no, that is that FIR has been lodged at the parental house of the petitioner.
Okay.
Out.
Well, take notice. Issue notice to the opposite party by speed post, fixing a short returnable date. The requisites be filed by tomorrow. Place this matter on 14th May. Yes.
IA is there. IA.
In the meantime, if any application is moved for adjournment on behalf of the petitioner in the court below, the same shall be considered, having due regard to the date fixed for hearing of this case. Yes.
Item number 6.
Please, your lordship. The petitioner is could be the inaction of the opposite party number 3 is not in act on basis of the recommendation given by the opposite party number 4 in terms of the new guideline under annexure 2 minor. It is the petitioner working as Anganwadi worker making a glance to annexure at page 14
Yes.
in 1993. So there is the annexure 2 in 2319. In a revised new guideline was introduced by the government increasing rate of descent from 60 to 62 years. There is a provision before 2 months willingness will submit along the submitted documents that will be forwarded by the CDPO to the sub-collector, and sub-collector will act on the basis of clause 4 and 4. The sub-collector will issue the order of re-engagement in the format prescribed, ensuring that
Where are you reading from? Annexure?
Page 17.
Page 17. Yes.
17. The guidelines, the last part 4.4.
Yes.
The sub-collector, the first one, the Anganwadi worker desirous getting re-engaged 60 years will give their willingness that I have complied. Prescribed relating to CDPO clear 2 month notice that I have complied. Then 4.2 proof of age will be ascertained that I have complied with certificate. CDPO receiving the request will forward the request to sub-collector certifying the format prescribing that the such and such has rendered satisfactory service recommending re-engagement. Then thereafter the clause 4 and 4 the sub-collector has to be
Issue the order of re-engagement.
Then your lordship making a glass on documents I have included annexure 3 series.
That's all right.
Straightway, then non-compliance annexure 4 I submitted. Then annexure 5.
Annexure 4 is the representation.
Then annexure 5 make a page 23 make a glass.
When represent the government, I am to inform you that So it was recommended by the
Annex
CDPO.
5 clearly demonstrate that reference 8 to 24 on the initial reference recommendation was there. When they did not acted upon,
Nase par author kole?
पुणे author remanded.
Well,
Still
that is
pending.
recommended. Then
Still it is pending before the sub-collector to
what is this order of this court?
order the previous writing that you are allowed to continue in on the basis of this circular.
Another case.
Another case.
This is another,
Not in connected.
So all you need is a direction to the sub-collector to act upon the recommendation.
Yes, that is
That's all.
that
Will
is
dispose
acted
of?
upon with the limited
Will
period.
dispose of? Yes.
Both the matters.
Look, the petitioner has approached this court seeking the following relief. The case of facts of the case briefly stated are that the petitioner was engaged as Anganwadi worker. Who jagata seta? Of?
मैंने अंगनवाड़ी वर्कर में लगा मुन्नागुड़ा मुन्नागुड़ा लास्ट लिखा है annex
Anganwadi worker of? Murunna. M-U-R-N-A. Murunnaguda Anganwadi Center
जूनागढ़ ICDS project
under the under which Gram Panchayat?
नहीं जूनागढ़ ICDS project
Under Junagadh ICDS project
district of
of
Kannada
Kannada district. By order dated 3/2/1993. Stop. Her date of birth being 3/3/1964, she attained the age of 60 years in March 2024. However, the government in the Department of Women and Child Development and Child Development and Mission Shakti their guidelines communicated on 2/3/2019 provided for re-engagement of Anganwadi workers for another 2 years till they attain the age of 62 years. As per the said guidelines, the petitioner submitted her application for
submitted supported by liquid documents.
wait. आपका मझिरे कहले भारी असुविधा है क्या?
Sorry sir.
मझिरे जेतु कहले आपण राखि दिन तारे.
Sorry man.
Mr. Mahathir, please allow me to dictate the order. If there is anything you can tell me, I will always correct it. समझ for re-engagement in terms of the guidelines along with all necessary and relevant documents. The CDPO Junagadh by his letter dated 19/3/2024 forwarded the request of the petitioner recommending her re-engagement, recommending her extension of service as per the guidelines. Stop. It is the petitioner's grievance that despite such recommendations and submission of necessary documents, no action has been taken by the sub-collector till date. Stop. Where is that 4.4?
The page 17.
As per the guidelines referred above, the sub-collector is to issue the order of re-engagement as per clause 4.4 thereof. Stop. Considering the limited grievance of the petitioner, this court disposes of the writ application by directing the sub-collector of Junagadh, bracket opposite party number 3, to consider the case of the petitioner as recommended by the CDPO Junagadh in his letter dated 19/3/2024 and take a decision in accordance with law as early as possible, preferably within
2 months because of the election.
2 months already she has crossed 60, but she had applied prior to that. Here, formal order issue, right? I'll say 2 weeks. Let us see. Within a month. From the date of production of certified copy of this order by the petitioner. Anything else?
Till then I may protected jadi पुनी से ଗୋଟେ issue करदे पुनी the further litigation in this.
What issue could they?
नहीं पुनी कहवे charge handover that till then I may protected.
It is submitted that the petitioner, since it is submitted that the
I'm
petitioner
continuing till now.
has been allowed to continue as Anganwadi worker by the CDPO, she shall be further allowed to continue till a decision is taken by the sub-collector in terms of this order.
But this
What is
19 circular also governed under revised circular 9B. ଏବେ 23 ମସିହାରେ ଗୋଟେ ରିଭାଇଜ କରିଛନ୍ତି କନସୋଲିଡେଟେଡ
recent circular will liquidate them. What is the connected matter?
same another petition.
Right, both the names of the petitioners have been given in that.
That is from which place?
worker
No, what I कोई जगह से CDPO
जुनागढ़
but the Anganwadi center may be different.
हां सेमी जमुना बहाल
In that letter, she has also, the CDPO has mentioned the names of both.
in 90 annexure 5 रे दीटा कमेंट
All. Yes, I.
totally 10 I mean sorry
Yes. Item 10.
Item 10, my lord.
Pass out for a moment. We'll see.
Item number 11, my lord, item 10, my lord, I'm appearing, my lord.
Yes.
My lord, so item 10 on the basis of the last order, my lord, the notice was issued to the OP number 3 and 4, my lord.
You are appearing for whom?
My lord, I'm appearing for the petitioner, my lord.
But she had taken back the file personally appearing in the court. And
No,
she had handed over the
Thereafter, I
file.
had appeared, my lord. Thereafter, I had
You have been
appeared.
engaged.
Yeah, I was engaged with the consent of the previous counsel, my lord.
Consent of कौन रहेगा?
हाँ, my lord.
Consent तो किसी रहेगा?
Yes,
This
my
is
lord.
Madhusmita Dutta, the petitioner appearance person. So they all right. Place the matter.
Yes, my lord. Thereafter, my lord, from the next date, my lord.
Just wait. There is another order I have not for. Okay. The notice was issued. Okay.
Yes, my lord.
What was notice? Notice in admission matter issued after storming to speed force to ready fixing it. Letter तो वो tag करियो ने आपको all right. Let's this matter next week. Office to tag the postal tracking report regarding service of notice on opposite party numbers. Who are they?
3 and 4, my lord.
3 and 4
Yes,
by speed post.
yes, my lord. My lord, service was already also effected on 5, my lord. And they have
I
not
think all
also-
right. Office note indicates that a notice has been served on opposite party number 5. Stop. बाकी ये वाला पापा लिखते हुए था. Yes.
item 11
Sir, actor Johnny court because
After how he requested, he did tell you.
he should.
Mr. Dani,
I because some mourning in the family, I cannot take any blame.
No, I was actually not willing to adjourn because he had not taken your consent. But then he said that.
Anyway, I'm bound to accommodate him, but because of the peculiar circumstances.
Yep.
Your lordship have adjourned to his date.
Next week. 30th April. He requested for next week.
30th.
Yes, he requested for next week.
Okay.
Yes, 11.
May I produce? This is relating to appointment of ASA, my lord. I am challenging the appointment of ASA of the opposite party number 5, my lord. You will also kindly see the last order.
Is the cause of action anymore valid? Does it exist?
Yes, fine.
2007 matter.
No, still, she is continuing. You will also kindly see the order dated 27/6/2016. Because suppressing the material fact.
So, who is appearing for the opposite parties?
Mr.
We'll do one thing, Mr. Mishra.
Kuresh Prasad Das.
Yeah, probably he's not there. I'm passing it over for some time.
Well,
Passing it over.
Right.
And today, if he doesn't come, I'll give one more opportunity and thereafter I will.
Mine.
All right.
Mine.
All right. See, ये तो खाली पासवर्ड कर देता दिखे. Yes.
item 12
Equal university, all right.
I am for the petitioner, my lord.
Yes.
My lord, even for roster duty not paid. University is writing to the petitioner is a retired
What is your prayer? What is your prayer?
My lord,
What is your prayer?
my prayer is release of my EL, my lord, towards my roster duty. I am totally, I retired on 31/1/2008, attaining 60 years, my lord. My lord, I have performed EL roster duty performed 457 days. So EL for 152 days. My lord, they have paid the normal EL, but the roster duty EL they have not paid. But the other employees, they have been paid towards roster duty EL. So when I approach them, they are telling that government has suspended it. That's why petitioner is approaching.
Where is that order?
My lord?
Where is that order? Where they say that government has suspended it?
That is running page 14, my lord. In response to your letter as cited above, I am to inform you that presently the authority in the university has withheld the payment of salary to the teachers on supervision against the EL and leave of the days of roster duty performed while service. This will be taken into consideration only after receive the decision of the government to this effect. My lord, the university and authority they have filed the counter, my lord. My lord, the government has not filed the counter in spite of your lordship direction since last several occasions to file the affidavit.
No, let us first ask the university council. Yes,
Sir, humble petitioner, sir. The 19.
let me frame my question, sir.
Yes.
I was halfway in my question when you interrupted me.
Sorry, sir.
Sir, in page 14, you say that this will be taken into consideration only after receipt of the decision of the government to this effect. Now, what decision was taken by the government?
So my humble submission is that on 19/3, 2024, I filed the power, my Baklapnama, and according to the instruction of the university, that already the disbursed is leave salary of 29 days. And they till now, I didn't receive all the petition copy and all the things from the previous lawyer that, so I'm not able to submit all the fact according to your question. I want some time to submit all the fact. But
Well, it's fair enough. He has appeared recently, so I'll grant him 1 week time.
Yes. Once my humble
The government also.
And my lord, within this week time, my lord, what your lordship now is to extend, my lord. Within week time, my lord, I will get the instruction.
Because you see, the matter seems to be hanging from 19 to 2013. We are in 2024, 11 years have passed.
In fact, my lord.
So some decision may have been taken by the government. We do not know. What is that decision? If a decision has been taken by the government, then it will give him a further cause of action to either challenge it.
Yes, I'll do that.
Either by amending the writ application or whatever.
I'll do that.
So you can't leave it.
Posted my lord to the next.
Your good name, sir?
Yes, sir.
Your good name?
Tara Prasad Acharya.
Sri Tara Prasad Acharya has entered. Have you already appeared or?
It's reflecting that.
19/3, 2000.
Okay. His name is reflecting. Sri Tara Prasad Acharya. Could not. Where is it reflecting?
Yes. Item number 13.
It is reflecting in the
Or list, my lord.
Cause list.
Okay, it has not been mentioned in the brief. That is why I could not talk. Sri Tara Prasad Acharya, learned counsel appearing for the university, he requests for a short adjournment on the ground that he has appeared recently and has sought for necessary instructions from the university. Learned AGA also requests for some adjournment, requests for an adjournment to apprise the court with regard to the present status of the present status with reference to the document enclosed. With
Under Annex 2.
reference to No, with reference to letter dated 19/2/2023 of the Deputy Registrar, Secretary General of the University.
19 to
From enclosed under Annexer 2 series.
pardon, my lord, 19 to 13, my lord.
19/2/2013, sorry, not 2003 koi thi. All right. Release this matter next week. It will come on next, on 30th of April. Be ready. Yes.
Item number 14.
On behalf of Mr. Ajay Kumar Pradhan, I may be permitted to submit my lord. My lord, here in this case, the sole grievance of the present petitioner is that being falsely entangled in a criminal case while discharging his duty as a Ganasikyaka in Kochilaberi Project Primary High School under the disposal of opposite party number 2, my lord, while the informant, being a victimized of a criminal case, has given the informant in this case has given a completely go by to the prosecution case, and that's why the present petitioner is completely acquitted from the case, my lord. My lord, but the opposite party number 2 rejected his prayer for re-engagement.
Facts kahin. Facts kahin. Security kama korthile, kon korthile, kon case hala, kon hala, kisko bani.
Coach.
Step by step jaan tu. Logical sequence se kon tu facts hota. Working as a Ganasikyaka.
My lord, the petitioner got appointment as a Ganasikyaka at Kochila Bellari Project Primary School of Battighara Gram Panchayat under Kendrapada district by engagement order number 1847 dated 14/7/2008.
Yes,
which is in annexure 1, my lord. And my lord, the petitioner
You are disengaged.
My lord.
Annexure 2.
Annexure 2.
On the ground of detention and jail custody beyond 48 hours.
My lord.
Not to be disengaged. Actually, it's an automatic. Yes, Mr. Patnaik?
Yes.
It is an automatic deemed suspension.
Yes.
10, section 10, rule 12, no, rule 10.
Rule 12.
Post-PC rule will have no application to such type of employees.
That's all. We have
Contractual employees, ma'am.
all right. Only because he was in custody, he has disengaged. Then what happened?
My lord. And my lord, the present petitioner faced trial in that case. And my lord, the allegation, if you will have to permit, I am going through the allegation.
Allegation.
My lord, the said allegation.
So that you were acquitted.
My lord.
Yeah.
Acquitted completely. The prosecution is. My lord. And my lord, after that, the present petitioner make a representation before the block education officer Mohakalapada on 19/5/2014 and then on 18/8/2014 to re-engagement in the said post, which is in annexure 4, my lord. Considering the same, the opposite party number 2, the district project coordinator SSA Kendrapada has been pleased to consider the grievance, but on 21/8/2014 rejected the request of the petitioner as the teacher will give a wrong message to the society, even though he has been exonerated due to failure of prosecution to prove the case, my lord.
This collector, have you gone through the impute order? He has interpreted the order of the sessions judge. Yeah, please come to page 23.
Yes, ma'am.
Based on the individual sentiment only.
Page number
paragraph 3 and paragraph 4.
Page note 23. Yes, ma'am.
Paragraph 5 actually. The result of the orders of the learned district and sessions clearly reveals that accused being aware of the serious consequences of the case has entered into a compromise with the father of the victim for which the father of the victim has become hostile.
His intention to say that, my lord, it is not an honorable act. It is a case which compromise.
Exactly, the sessions court should not have mentioned the question of compromise. Yes. Should have simply said that there is no evidence, nobody has, everybody has become hostile. Basically, yes. With that. However, the entire episode, starting from the allegation of unfortunate and heinous crime committed. What is the law? Position of law?
12. And another one, the OCS rule 15, that there must be a so-called notice and the charge sheet.
No. That it is not. It is not. It's a contractual appointment on the basis of agreement.
My lord. I am coming with the decision of my lordship. Yes, lordship.
I may have passed a wrong order.
No, my lord.
Yes. No. What is the what I want to know what research you have made?
Yes, my
What
lord.
is the law? When acquittal in a criminal case, what effect it will have on the departmental proceeding or the inquiry?
My lord,
Which is the leading decision in this field? Have you gone through any decisions?
no, my lord. I gone through this, which is applicable to me.
Go through one decision.
My lord.
Captain N. Paul Anthony versus Bharat Gold Mines or something like that. I would more man nahi, baki to koi bhi nahi.
The recent 2023 of the Ramlal decision.
But it is always that that decision is the leading decision. Ask your senior, he will give you. Yeah. There they have laid down. What is they have made a comparative, isn't it?
Yeah, now the recent decision says there is no concept of honorable acquittal. So some more relief has been granted to the petitioner.
Because how do you define honorable acquittal?
That is not well stated by.
I give a sessions judge, I don't know what is the meaning of honorable acquittal. Acquittal or conviction? There are two things. Whatever may have.
There are some decisions.
Here what has happened is the court below appears to have that paragraph which he has quoted. He could not have said that compromise. He should not have used that word compromise. Isn't it? He may simply have said that the witnesses have not supported the prosecution. That's all.
Stated miserably failed.
No, see, miserably failed मानने की चीज़ नहीं था. ऐसा रहो तो लिखा जाए simply. So you do one thing. Officer.
Well, I think there is an IA.
Is it?
There is an IA of 2680 of 2024 for bringing certain documents to the record.
What record do you want?
My lord, IA is regarding that the new amendment that as per the 2000.
She had to succeed in the writ application. That only.
After such.
What is this judgment?
My lord, Abhimanyu Malik versus State of Orissa.
What does it say?
My lord, it is stated that this person is convicted for the offense under section 302 and inside the jail custody without any so-called notice, without any charge sheet frame. The person is disengagement from the duty as that is misconduct. And your lordship is in para 8, it is specifically quoted that the question is can mere involvement in a criminal case to be held as a misconduct. It is well known in the criminal jurisprudence that an accused is presumed to be innocent till proven guilty. The condition in the agreement at clause 9 referred above speaks of misconduct, which obviously means misconduct that has been duly proved. Mere allegation.
No, he was governed under 2013 rules. Being a contractual employee, I heard that he was governed by the 2013 rules as it stood then.
And another point also your lordship had taken into consideration in that case, that by that time he had already completed that particular required period of service and his name was very much available in the regulation list.
This is on a different footing. This will not help you. Maybe to some extent, but again, you go through the Captain N. Paul Anthony's decision. This is matter. We take it up on. We'll finish it this week itself. Day after tomorrow.
May I pray only? In this case, my lord, in fact, we have not filed any counter. With on the last occasion on 5/2/2024, my lord, since there was a direction that an IA will be filed. So, my lord, with that impression, my lord, actually I contacted by the authorities, but I could not file the counter, my lord. What are the new facts which are going to be taken into records? So this matter will be taken up on 30th, my lord.
No, that's all right, but it may not be necessary because it is the order of the collector which is under challenge.
But
all right, third in part, let's this matter next week.
Yes, on 30th.
No, that is 6th May. 6th May. 7th May. 7th May. But next 7th May.
So yes, sir.
I know. When you come to the court, first prepare, see the law.
This is for the very first time I'm getting this.
No, nothing. Yeah. You be master of facts, but at the same time, you must be ready also with the point of law. But basically, facts, if you are ready with the facts. More than applicable. It is not applicable. Where that is contractual appointment rules 2013. Yes.
Item not 16.
15 ta kaun hai? Item 16.
May I please, sir?
Yes.
Sir, I am appearing for the opposite party, sir.
Opposite party. Yes, Mr. Nanga.
The husband, sir.
Your matter.
Item 16.
Yes. What are you waiting?
In this case, my lord, the petitioner was married in the year
You want the case from transferred to, from which place to which place?
from Bhubaneswar to Cutter. Because the petitioner, very old, poor lady, is unable to meet any legal expenditure.
Sir, may I please, one request, sir?
Yes.
Sir, this case may be sent to mediation.
And the CP was filed while she was in matrimonial house. She received that and stayed there also without asking elder persons. Nobody cooperated.
This is a 13-1 application, isn't it? 13-1 application filed by the husband against you.
The reason is,
No, whatever may be the reason, Mr. Nanda, why don't you file a, why don't you approach the court for, approach the mediation center?
my lord, I have filed a 121 CRPC before the family judge Cutter. And learned family judge is interested for mediation in her court, and the opposite party is regularly filing time petition there. They are not going there.
No, I will fix it at High Court Mediation Center. I will keep this pending. If mediation succeeds, well and good, all the cases will be taken care of. If they don't, then we'll consider this.
Yes, sir. I have no objections.
In course of hearing, it is stated at the bar that the dispute between the parties being is of such nature that an attempt can be made to resolve the same amicably through the process of mediation. Stop. In such view of the matter, let the records be placed before the coordinator, Odisha High Court Mediation Center, who shall do the needful. Stop. The parties shall act pursuant to notice received from the mediator and render full cooperation in the mediation proceeding. List this matter on.
After
Vacation for 25th June. 25th June. Interim order to continue till then.
जुलाई को रखन्तु कारण 11 of July रे अछि भुवनेश्वर रे
ଶୁଣନ୍ତୁ ଏଇଟା ଜୁଲାଇ ଏଇଟା ଜୁନରେ ଥାଉ if necessary we'll adjourn it
25th of June.
Yes.
Problem.
Item 17.
Item 17 on behalf of Mr. Kondak, I will take note next week.
All next week as paid for 7th May.
Item number 18.
This is content to but on the last occasion, your lordship had directed to list this case tomorrow, my lord. On 24th.
So the dismissal of the application registration is pending. It requires some time to obtain. You wanted to take instruction with regard to the SLP.
SLP.
But 24th of April actually. आज 24th नहीं की? Oh. अच्छा. Please this matter tomorrow as directed earlier. Tomorrow. You obtain the instructions.
Today I have already intimated.
No, but tomorrow it must be there.
Must be there.
Item 17 interim order to continue.
Item 17 interim order to continue.
Item 19.
May I please your lordship? Like the case, the offense involved in this case is 130 of the NI Act, my lord. What is this? The transfer, my lord, transfer petition, my lord, for the ground of, my lord, 4071C, my lord, on the ground of convenience of the parties, my lord. Lordship kindly see, my lord, the annexure 1, my lord. My lord, page, my lord, 13, my lord. The complainant, my lord, belongs to resident of Athagor.
What is the 138 NI Act?
My lord.
To negotiate करेगी सारा तो negotiate करी सारा mediation सारा 138 NI Act, you will find it out. What, Mr. Jana?
What happened in this case, man?
You are for the complainant.
Sole opposite party.
Complainant.
Complainant.
Where the complainant is the accused. What is the check amount?
But in fact,
One were two check amounts, 140 lakhs, 112 lakhs.
Yes. Why don't you settle it?
they are not ready to settle the matter because, my lord, your lordship may kindly see my written objection, wherein, my lords, the present petitioner filed an FIR against me. And against that, my lord, I approached for your lordship, my lords, I mean, anticipated bail applications. In that matter, my lord, your lordship referred that matter to the mediation center for the settlement, my lords. And none of the time, he turned up to the mediation center. And before was there, my lord, I also enact, my lord. But subsequently, your lordship was inclined to grant the anticipated bail to me, my lord. So in this, my lord, if your lordship, and again, will refer the matter to the mediation center, then they will not turn up, my lord. That is my
all right. Yes,
my lord.
Let us hear the transfer application on its own merit,
my lord.
So you want this 138 NI Act case to be transferred from
from the Malkanagiri to the Hindu or any convenient place of the of all both the parties.
Why Malkanagiri?
That is my question. Why the Malkanagiri?
You are regarding at Kotak.
No, he is residing
at asking him.
Minor.
You are residing at Kotak.
Minor. And one thing,
why did you file it at Malkanagiri?
Because my lords, the check was my lords presented in the account of mine that is situated at Malkanagiri. My lord, I was also having business transaction in that locality also.
Gotta Katha suppress question brought to the notice of this court. When the petitioner came to anticipatory bail, he is showing an account to ICC and Bhubaneswar, in which the transaction between the accused and the petitioner. And why did not produce the check in Bhubaneswar, my lord? He chose in Malkanagiri, my lord. Though he is a resident of Athavada and I belongs to Dhenkanal, both are my lord, to that locality, my lord. And that based on that account, my lord, he showing that the transaction with the petitioner in the.
No, that's all right. But why didn't you appeal for the mediator?
That is a communication gap, my lord. Myself and the informant, my lord. That's why, my lord, he could not come, my lord.
No, if you make a positive statement that your client is ready to settle the matter, the court is willing to consider that.
But I'll take instruction.
Lordship may kindly see my written objection. Page, my lord.
Mr. Jana,
Mr. Jana, given, I'll take instruction.
Mr. Jana, if we are to hear the main application on merit, we will hear it.
No, I'm not saying that.
No issues. But I have asked a simple question to him, that whether his client is ready, because you have referred to the earlier mediation thing, which he says that because of communication gap, and I will believe the lawyer. I will believe the lawyer. Whatever may have happened, actually, this court will not enter into that. When a lawyer, learned counsel submits so in the open court, that will be recorded. Yes. What is Mr. Behra advising you? Person in trouble also, but again, you yourself will be in trouble if you transact Malkanagiri.
Our place of business and accounts, everything is maintained there.
So before we enter into this merits of this case, I would again suggest that you may try for mediation to settle the dispute. It's up to you.
Yes, apprehensions that you not, because the other side has tried to put.
This court will take note of that conduct. This court will take note of the conduct. I'll record that. Whatever Mr. Jana said, I'll record it. Whatever you say.
In the last occasion, your lordship has directed us to find out the precedences. In minutes, directed us.
Precedent what?
Precedental law regarding minority transfer. That is the merit of the case.
I will go to that. I will go to that. I'm not saying that. If it is settled, well and good. If it is not, because these matters are better settled.
Yes.
The kind of cases that the kind of burden that these cases are now posing on the courts.
Yes.
You know, at least you must be aware of the workload of the Bhubaneswar magistrates. 138 and lakhs of cases.
Yes.
In lakhs.
Yes.
So unless these are settled, it will be very, very difficult.
Anyway, what Mr. Behra is saying, my lord, regarding merit of the case, that jurisdiction part.
Yes, I will
so that will be hard on merit.
If necessary, we'll hear it on merit. This court will not shy away from doing that. Anyway, in course of hearing, this court posed a query to the parties, to the learned counsel, I think for the parties, as to whether there is any possibility of settlement of the dispute amicably. Stop. Sri P.R. Singh, learned counsel for the petitioner, submits that this client is ready and willing to settle the matter. Stop. Sri Jana, learned counsel appearing for the opposite party, submits that in an earlier case, this court had directed the parties to settle the disputes through mediation, and had referred the case to the mediation center. But the same could not succeed due to non-appearance of the present petitioner. Stop. In reply, Sri Singh submits that the petitioner could not appear because of a communication gap between him and between him and his client. Stop. He, however, undertakes that this time the petitioner shall appear. Correct? In view of such submissions and undertaking, of the learned counsel, let the case records be placed before the coordinator Odisha High Court Mediation Center, who shall do the needful in the matter. Stop. The parties are directed to appear pursuant to notice received from the mediator and to render full cooperation in the mediation process. Let's this matter on just Chutti Purvu go to date karo. Go to date karo so that interim report I'm aware whether he is appearing or not.
21st May.
On 21st May, last working day. All right. Let's this matter on 21st May. On which date the office, on which date the mediator shall submit an interim report of the mediation conducted thus far. Mediation. Stop. Is there any interim order? Yes. Interim order to continue till then. Deeply.
Item 20.
It's a transfer application filed by the wife Mala. Husband filed a divorce application at the family judge Jagatsinghpur Mala. Wife residing at Pahara for that district for that district.
Jagatsinghpur Khorda କେତେ ବାଟ କି? Jagatsinghpur ପାହାଡ଼ କେତେ ବାଟ? ଏ ଭିତରେ ଗୋଟେ ବାଟ ଅଛି ସାଙ୍ଗେ ସାଙ୍ଗେ ପହଞ୍ଚିବ କଣ?
70-80 କିଲୋମିଟର। 80 କିଲୋମିଟର।
ବହୁତ କମ। 70 ଏପଟେ ଗଲେ 70।
ଭୁବନେଶ୍ୱର 80
Who is
କିଲୋମିଟର।
appearing?
Oh, I am appearing for the opposite party, sole opposite party.
Yes. ଆପଣଙ୍କ ନାଁ ଅଛି?
ନାହିଁ ଏଇଟା କନସେଣ୍ଟରେ appear କରୁଛି।
Consent?
ହଁ।
ଆଚ୍ଛା। ଶ୍ରୀ S.K. Raut, advocate and associates have entered appearance for the sole opposite party after obtaining no objection from the previous counsel. Stop. Wakamatnama so filed be kept on record. Their names will be reflected in the count list. Yes, mediation?
Yes, sir.
Ready? Same order pass kar dunga. In course of hearing, it is stated by learned counsel for the parties that the matter can be, the dispute between the parties can be resolved through mediation. Stop. Hence, the case records be placed before the coordinator Odisha High Court Mediation Center. Yeah, let's this matter on 21st May. That's what you
25th June.
25th June. Is there any interim order?
Yes.
Interim order to continue till then.
Item 21.
May I please ask? I am
Insufficient address.
petitioner wife Mallard.
File requisites.
Yeah.
Item delivered. Yes, yes. Item has been delivered.
In this petition Mallard, I am for the petitioner Mallard wife Mallard. Last occasion.
Notice on PIP matter issued to sole OP by speed post with AD returned undelivered. With postal endorsement insufficient address. But postal tracking report says that item delivered. What? How?
Mallard affected by the opposite party, which he was filed Mallard in CP case Mallard. That is Mallard, I have sent it Mallard.
Office note indicates that a notice issued to the sole opposite party by speed post returned undelivered with postal endorsement insufficient address. The postal tracking report, however, shows that the postal article was delivered. Office to verify and list this matter next week. କେମିତି ହେଇଛି ମୁଁ କିଛି ବୁଝିପାରୁନି 17 ତାରିଖରେ undelivered କେମିତି ହବ ଏପଟେ ଲେଖା ହେଇଛି delivered yes
so item number 11
item 11 your matter no ये पासवर्ड करथिले मु काल के आसी होली तो Amir Kumar Mishra and counsel for the petitioner is present. None appears for the opposite party. List this matter next week.
Next,
7th May.
Item number 23.
Separate for each one.
23.
Maybe it's a dispute matter.
Oh, matter 2023 ଏବେ କାହିଁକି ଏଟା ଆସିଲା
It was a letter from the.
Letter is seeking extension till 2020, August 2023. Why was it placed now? Why is it placed now? The letter of additional sessions judge from special judge in charge Jaipur was received on 21/7/2023. Office to submit a report as to why this letter was not placed before this court earlier. List this matter next week.
Item 24.
Out of 10 years sentence, my lord, the petitioner now in the jail in custody, 6 years, 3 months, my lord. Offense under section 307, my lord. In 24-25 Arms Act, 3 and 4 Excelsior.
PW
1 and 8.
1 and 8 have stated about you.
Last occasion, your lordship rejected in that ground, my lord.
It is not rejected.
Yes, my
Was
lord.
it rejected? No, no. When was it rejected? I rejected it. Yes, on 1/11/2020. 1/11/2020.
Now he is jail in custody 6 years, 3 months.
IA 806 of 2024. IA has been filed seeking bail on the ground that the petitioner, that the appellant has been in custody for more than 6 years, 3 months. And that he being the only, and that his widow, mother, is suffering from various ailments and is bedridden. Stop. There is no other person available to take care of his mother. As such, stop. Learned State Council has opposed the prayer for bail by submitting that the petitioner's complicity in the alleged occurrence was well proved from the evidence of PW 1 and 8, considering which this court was not inclined to grant bail to him earlier. The petitioner will be appellate through. This court observes that by order dated 1/11/2022, the application for bail of the petitioner was rejected. In the meantime, the present application, however, the present application has, however, been filed citing the ground of illness of his mother. Stop. Since the petitioner has spent more than 6 years and 3 months in custody out of the substantive sentence of 10 years, and on consideration of the grounds cited in the petition, I am inclined to take a lenient view. The IA is disposed to let the petitioner be released on interim bail for a period of 4 months. Petitioner is appellant करता है.
And 25.
Wait, please, madam. Madam, say break for after lunch.
After lunch again, that will be difficult. Call it. Okay. Yes.
Congratulations.
You are ready?
My lord, they have prayed for interim.
Interim.
All right, we'll see. Yes.
Item 26.
May I please, Your Lordship? Your Lordship, for extension of time, Your Lordship.
First time?
Your Lordship.
2 weeks.
Obliged, Your Lordship.
Item 27.
My lord, extension of time, my lord. I will receive, my lord.
Is it for the first time?
First time, my lord.
All right, 2 weeks.
Obliged.
28.
28 and 29.
Yes.
Your Lordship had granted
a slight modification, I need extension. Your lordship had granted 2 weeks on 8/2/2024. Arising out of the localized matters where your lordships have held.
Or to surrender, 2 weeks to surrender. You want 2 weeks for the time.
Probably 4 weeks then. So difficulty was this one. Probably more ଅଧିକା ହେଇପାରିବ ଆଜ୍ଞା ମୋର କଣ ଅଧିକା ହେଇପାରିବ ଯାହା କହିବେ ଆପଣ 3 ଦିଅନ୍ତୁ ଆଟଲିଷ୍ଟ
କାହିଁକି ଭାଇ
ନା ସେ ଆସିକି ସାମ୍ନା କରିବେ
ନାଇଁ କରିବ 2 weeks surrender liberty
I'll not bargain on that. Luckily, we're going to indicate करदो vigilance PS case number 51 of 2022 corresponding to TR case number 20 of 2023. Pending in special judge which vigilance Cuttack.
Considering the submissions, the order dated 8/2/2024 is modified in the following manner. 1. After the words 51 of 2022 occurring in paragraph 3, the words corresponding to TR case number
vigilance PS case number 51 of 2022 corresponding to TR case number 20 of 2023.
20 of 2023.
Pending in the court of special judge, vigilance court Cuttack.
Pending in the court of
special judge, vigilance Cuttack.
How is vigilance to work? Special judge vigilance Cuttack be inserted. Do you relate to 2 weeks further time is allowed to the petitioner to surrender in terms of the order.
Grateful.
What about the other?
Same modification.
Case number and the court name is also the same.
Same.
All right.
Same. There were 4 other matters. I'll give a slip, my lord, sir.
Yes, it will be taken.
Chota thila sidna. Dita aschi aur chatta aspen.
I see. Limited matters are coming. Fixed matters are coming. So.
Kali jodi list kar diyante. I don't know.
I'll get them listed. Yes. The connected matter. Kali to yeah order hobo.
Grateful.
Item 30.
Lakshmi, condone my happiness tomorrow. I may not pay.
Somebody will be there. Anybody you ask.
Grateful.
Petitioner is the driver, my lord. Beef was transported by a vehicle and the owner of the vehicle was granted.
It is a regular bill.
No, my lord.
And it's good bill.
My lord.
Where will it come in the supplementary list or I have no use? One Sheikh Abdul Wahab has been granted.
Yes. He is saying he is the driver of the vehicle. FIR actually driver of the vehicle. None.
Same order will pass. Same order.
Item
No,
31.
you say that here the other person is the owner of the vehicle. You are the driver. So it is it is alleged that the petitioner is the owner of the vehicle. Driver of the vehicle. Click on that. Item 31.
May I please your lordship? On behalf of Mr. Khontia, your lordship, I may be permitted.
The date of adjournment is enabled at 6/4/2024. What is it?
By order dated 15.
6th April. The word April occurring in paragraph 4 of order dated 15/4/2024 be corrected as May. Stop. Please. May here allow. The weekly list.
Weekly list item number 46.
Hello.
Item number 47.
My lord, petitioner is custody since 14th August 23 and being implicated a case under section 376 in the
My lord, the victim has been examined. PW 8. Item number 50.
Yeah, lordship. There are 2 accused persons, my lord. Involved under section 20B2C of the NDPS Act, the quantity of ganja seized is 40 kgs. 40 kgs. I submit before my lord that the place of seizure and detection is 12 kilometers distance from Jaipur Sadar Police Station, and the witnesses to seizure belong to different places.
Case diary is not available. KG. Well, Mr. Khora, you have to adjourn it because we need the case diary. The state council doesn't have the case diary. Let the case diary come, I'll consider your up-to-date case diaries be produced. Let's this matter on.
We commencing 6th May.
Yeah?
We commencing 6th May.
6th May. All right. In the week commencing 6th May. 6th May କୋଉଠି ଅଛି ଜୟପୁର ତ ଆସିବ କଣ? Week commencing 6th May.
Item 51.
Please, my lord.
Thank you.
Yes, the petitioner is alleged.
Password.
53 and 67.
Password. Yes. 50.
Item 54.
May I please? Malad 20B2C, malad 28 kg 700 gram, and the petitioner is in custody since 18th September 2023. Allegation against the present petitioner, malad, he was the driver of the offending vehicle, and the contraband article.
Since when are you in custody?
18th September 2023.
Yes. Yes, my lord. The petitioner is in custody since 18/9/2023 in connection with such and such case. It is alleged that contraband ganja weighing 28 kg 700 grams was being transported in a Santro car. You were driving it?
No, my lord.
Yes, you were sitting in the backside of the Santro car in which the petitioner was an occupant. Okay. It is submitted that the petitioner had no knowledge of the articles being transported. Are you the owner of the car?
No, my lord.
And that he had he was traveling on hire. Stop. It is further submitted that despite being in custody for more than 6 months, no steps have been taken to commence the trial. He further submits that the mandatory formalities relating to search and seizure were not followed. The next state council has opposed the prayer for bail, submitting that the petitioner being present in the vehicle, the contraband must be treated as being seized from his possession, from his constructive possession. Stop. Considering the submissions, the materials on record, and the period of detention in custody, I am inclined to allow the prayer for bail. Let the petitioner be released. Each day appearance.
Item 55.
I may please,
Item 55.
Petition.
Item 55, you are appearing.
On behalf of Mr. Rasmi Rekha Panda.
In the second matter, I am.
Yes.
Here, my lord, I am in custody since 12/10/2023. My lord, charge sheet has been filed on 7/12/2023, my lord, on section 419, 420 by 34 and 66C and 66 YTI.
CMD. What is the allegation? Let us see the allegation.
My lord, in course of the investigation and ଗୋଟେ ଦିଟା କଲେଜରେ ସେ ବିଷୟରେ ମିଟିଂ କରିଥିଲି ଏବଂ କହିଥିଲି ଯେ ଏଥିରେ ଆପ୍ ଡିପୋଜିଟ୍ କର। My lord, my
two brothers. The other two brothers, the item, second item, the other two brothers, they organized a meeting. And allowing the general public to deposit money, higher interest may be, but I will seek some specific instruction, my lord.
No, this should be a OPID matter.
Charge sheet has been filed, but
Interim material, my lord, 2 accounts have been seized of mine. But nothing has been deposited in my account. My lord, my humble submission, in course of the investigation, 2 accounts of mine has been seized. My lord, nothing has been.
Yeah, that is true, but let him take instruction, so we'll take it up next week.
Yes, my lord.
My lord, instruction, they have already taken 4 dates. Problem is, your lord, the app was there. App doesn't belong to us, neither in our account money has come. We might have personally
that instruction I have to
some
take.
people to invest in order to get better return. Now that app is closed, they say. And the investigation police has not recovered any account connecting us with the money that it has gone to.
He just wants 1 week time.
That specific instruction I have to take, that whether any money has been transferred to them.
They are saying the main culprit, she is yet to be apprehended. Some lady, my lord.
So we are not interested in that. That will not be a ground to detain you in custody.
Even your lordship's charge sheet, my lord, not a single word whispered interests us, my lord.
Charge sheet has been filed.
Charge sheet
In December, and by the crime bench itself.
I mean, bar of the
London State Council requests for, no, London State Council is directed to take specific instructions as regards the as regards the allegation against the petitioners and their financial implication, if any. Let this matter in the week commencing 29th April.
Yes.
Yes, yes. No, weekly list to the
Item 56. 29.
My lord, your lordship was pleased to have this matter and was pleased to direct the state council to obtain the statement of the injured Shakti Charana Mahanti. I mean custody, my lord, since 6/8/2023.
What happened to that?
Yes, that statement has been.
Statement is there, ma'am. There is difference in witnesses statement and the injured statement. Plus different. Injured stated that the present petitioner has taken him to the hospital. Witnesses stated that the present petitioner was spread away from the spot. That was the allegation.
Who is that injured?
Injured, you may say Shakti Charana Mahanti.
So who is the assailant?
Assailant ଆଜ୍ଞା ସେ ନିଜେ କହୁଛି ଆଜ୍ଞା injured ଯେ ରାଜା ଆଲିଆସ ନିଶ୍ଚିତ ମତେ ଗୁଳି କଲା ସେ other cooperative person. ରାଜା ଆଲିଆସ ନିଶିକାନ୍ତ ମତେ ଗୁଳି କଲା ଉକ୍ତ ଗୁଳି ମୋ ପେଟରେ କଟି ମୁଁ ସେଠାରେ ରକ୍ତାକ୍ତ ହୋଇ ସେଇ କଳଘର ପିଣ୍ଡାରେ ମୁଁ ପଡିଗଲି ଗୁଳିର ଶବ୍ଦ ଶୁଣି ଗାଁର କିଛି ଲୋକ ଆସିଯିବାରୁ ରାଜା ସେନାପତି ଆଣିଥିବା ବୁଲେଟ ମୋଟରସାଇକେଲରେ ମୋତେ ଆଣି ମାର୍ଶାଘାଇ ମେଡିକାଲରେ ଛାଡି ଲୁଚି ପଳେଇଲା ମୁଁ ତାକୁ ନେଇକି ଆଜ୍ଞା ମେଡିକାଲରେ ଛାଡିଛି.
So this Raja Senapati is different from that Nishikanta.
ହଁ ସିଏ ଅଲଗା ଇଏ ଅଲଗା.
There is two Rajas, ma'am.
ସିଏ ହଉଛି ଆଜ୍ଞା
Raja Senapati.
ରାଜା ଆଲିଆସ ନିଶିକାନ୍ତ.
Nishikanta
ଆମେ ହଉଛି ଆଜ୍ଞା
Raja Senapati.
ସେନାପତି.
That Raja, he has fired. Then Raja is Nishikanta.
As Director, London State Council has produced the 161 statement of
injured
Shakti Chandran Mahanti, the injured. Stop. The petitioner is in custody since
6/8/2023.
6/8/2023 in connection with such and such case. It is the FIR was lodged against unknown culprits who had allegedly fired a gun at the son of the informant. Stop. The injured in his statement has stated that one Raja alias Nishikanta had fired from his gun at him, causing the injury, while the present petitioner being Raja Senapati, Raja alias Vivekananda Senapati, took him to the hospital on his bullet motorcycle and thereafter fled away. Stop. Having regard to the fact that there is no allegation of assault against the petitioner, I am inclined to allow the prayer for bail. Let the petitioner be released.
Published.
Item 57.
Here, my lord, case under section 302, charge sheet has been submitted and informant was examined, my lord, and I have annexed the copy of the deposition of informant. Here, what happened, my lord, the informant is the father of the present petitioner, and the deceased is the mother of the petitioner, my lord. Here, my lord, your lordship may kindly turn to page 23, the brief facts of the case attached to the charge sheet. I have filed the copy of the charge sheet. The death is purely accidental, my lord. If your lordship kindly turn to, my lord, that page 23, last para, that conduct local and confidential inquiry, starting from conduct and found complainant Lakpati Parija is the permanent resident of so and so, whereas his wife deceased Puspanjali Parija belong to village so and so. They have two sons, namely Sunnam Parija. Sunnam Parija is the petitioner, and Mrutyunjay Parija. Sunnam Parija married to Lina Parija, and they had one son and three daughters. One of twin daughter, namely Elisa Parija, aged about so and so, has been brought up since 2-3 months of birth by her grandmother Puspanjali Parija. On the day of occurrence, that is on 15/4/2023 at about 7 p.m. while the deceased Puspanjali Parija was holding her granddaughter Elisa Parija on her lap at the time, father Sunnam Parija, son of the Puspanjali Parija, came to take her to feed Miller. But her grandmother did not leave her. He asked for his daughter again to leave only to feed her. But Puspanjali Parija did not leave her grandfather. Then Sunnam Parija quarreled with her mother and forcibly took his daughter from her. He also beat her mother to get her daughter out of her hand. In this tussle, he also kicked on her mother's belly. Then he pushed her mother forcibly and snatched her daughter. As a result, she lost her balance and fell backward, hitting the back of her head on very hard and rocky surface on the ground. As a result, she became unconscious and thereafter died. And in the meantime, informant was exhausted. That is at page Annexure 3 series, at page that is 26. He stated that he is not supported. Father, he is the father of the petitioner, and petitioner is in custody since 1 year.
Informant became hostile, my lord. But 3 other eyewitness, they have seen the assault. However, my friend read in the charge sheet, one Nilambar Naik, Anjali Naik, and Lucina Naik.
7 hostile agent. କିନ୍ତୁ ଇନଫରମାଣ୍ଟ ଡିପୋଜିସନ କପି ସବୁ ଅଛି, ମୁଁ ଆଜି ପାଇଲି, କିଛି ନାହିଁ your lordship.
ନିଲମ୍ବର ନାୟକ, ଅଞ୍ଜଳି ନାୟକ,
ଦେଖି ଦିଅନ୍ତୁ,
ଦେଖିବି କାହିଁକି ଆପଣ ତାଙ୍କୁ କପି ଦିଅନ୍ତୁ, ଏଇଟା ପାସ୍ କରୁଛି କାଲି ନେବା. We'll take it up tomorrow. These 3 witnesses, they said regarding the assault and give copies.
ମୁଁ ଏବେ କପିଟା ଦେଇ
May I please?
pass over for the payment.
Yes, may I please? Madam 20B2C of the NDPS Act, madam, and the present petitioner name is Prasad Anupal. Madam, on the date of occurrence, madam, one blue color Tata Intra V30 AP 39 UC 2238 and TVS Apache motorcycle OD 30 E9006 and Hero Glamour motorcycle OD 30 D1259 have been seized by the police, madam. And 4 persons apprehended, that is Bhajan Das, Madhav Khemdu, Babla Hantal, and Jacob Khemdu. They disclosed that one Prahlad Hantal was driving the 4-wheeler, and one Ramapangi was the pillion rider of the motorcycle, and Bingu Khilo and present petitioner, they were financer of the contraband article, and contraband article is 625 kg, madam.
Yes, madam.
In this case, madam, the financer Bingu Khilo and Prahlad Anupal, out of them, Bingu Khilo released on bail by this report, and other accused person Rampangi, Prahlad Hantal, who absconded from the spot, they released on anticipatory bail, madam. And similar footing, madam, one Bingu Khilo released on bail.
Bingo Khilo financier. Present petitioner along with Bingo Khilo,
both are
they are rallied as financier and supplier, madam. You are Babula Hotal?
No, my lord, Prasad.
Prasad Anupal.
Anupal.
You can pass similar order? My lord. Fourth person apprehended from this two from Tata Intra and two motorcycles, and the petitioner is in custody since
8th November 2023.
in connection with such and such. From the case diary, no, it is submitted that the contraband weighing kete
620.
weighing 628
25
kg. 25 kgs was recovered from the possession of one Madhav Khemundu and Babula Hantar. Bhajan Das, Madhav Khemundu
and Jacob Khilo.
ये दी जन गना लिखे जैसे माधव खेमुंडू कमा बाबूला हंताल कमा जैकब खिलो and Bhajan Das. Insofar as the petitioner is concerned, his name was disclosed by the who disclosed his name?
My lord, Bhajan Das, who apprehended at the spot.
The co-accused Bhajan Das, who was apprehended at the spot. There is no evidence to show the presence of the petitioner at the spot or of possessing the contraband. The co-accused persons standing on similar footing, namely Bingu Khilo, Asutosh Mistry, Prahlad Hantar, and Rama Pangi, have been released on bail as per orders passed by this court in separate anticipatory bail applications. Stop. Since the petitioner stands on the same footing, I am inclined to allow the court to bail. Let the petitioner be released each day appearance.
Obliged.
Item 59.
May I please, minute. The petitioner has been undergoing incarceration since 2023 minute for an offence punishable under section 376(2)(n).
Of rupees 12 lakhs and 12 lakhs 4,000
That has been recovered.
Has been recovered.
But 11/2023. That has
The petitioner.
been done.
The petitioners are in custody since 4/11/2023 in connection with such and such case. It is alleged that the petitioners were transporting contraband ganja weighing
29 kg, 410 grams.
29 kgs, 410 grams in a car when they were apprehended by police. So it is submitted that the statutory formalities relating to such and seizure were not complied with. Stop further. The mode of payment of the contraband is also doubtful. Whether State Council has opposed the prayer for bail by submitting that the contraband was recovered from the conscious possession of the petitioner.
petitioners. Stop. Considering the 11 ବର୍ଷରେ ହେଇଛି ପରା 11 ବର୍ଷରେ ତ 6 ମାସ ହଉନି
near about 6 months. Charge sheet has already been submitted.
so I'll release you on interim bail, then we will see.
ଅଛି मैं କାଲି release
ସମସ୍ତଙ୍କ ପାଇଁ ଗୋଟେ 6 ମାସର ଇଏ ଆପଣଙ୍କ ପାଇଁ
driver owner ନାହିଁ driver ଆଉଟା ହଉଛି
again no case the kingpin is arrested, that we know. I was conducting trial, I don't know, you know better than me. What are you saying?
5 months 10 days to 12 days ହଉଛି
She will not upload this order for about the remaining 20 days. 6 months. Considering the submissions and the materials on record, I am inclined to allow the paper bail, let the petitioner be released. Each day appearance.
Oblige.
Item number 61.
Sure.
My lordship, my lordship, my lordship.
Yes.
The accused is in jail custody since last 1 year. The age of the victim is 16 years.
Notice has issued.
Hello.
What about the notice?
My notice was served on 25th. Sorry, madam, notice was served on 16/4/24. 16/4/24. But she has written a letter, madam, that she is incapable to appear before this court due to financial condition.
So we'll engage a lawyer from the legal aid?
Yes, madam. It will be better.
Why don't you file that letter?
Madam,
you file that letter.
I will file, madam.
Yes.
Later, you will pass that order. I will get it.
Learned State Council submits that notice was duly served on the victim, who has written a letter stating that because of financial stringency, she is unable to appear before this court. Stop. Considering the letter of the victim, the Secretary, High Court Legal Services Committee is directed to engage the lawyer from the legal aid panel to conduct the case on behalf of the victim. A copy of the brief be supplied to such lawyer after his appointment. Place this matter in the week commencing 6th May. 13th May. This will come on 13th May. Notice has to be served on the victim. Notice has been served, but the victim says that we are engaging a lawyer for the victim through the legal aid. Okay. बुझ पा गया?
Sir, it already says lawyer ଦେଇଛି ବୋଲି କାଲି ଜଣେ advocate present ଥିଲେ. ଆଉ second ଜିନିଷ ହଉଛି sir till date ମାନେ ଚାର୍ଜସିଟ୍ ସବମିଟ୍ ହେଇନି।
ତ
ଆଜି ପର୍ଯ୍ୟନ୍ତ ଚାର୍ଜସିଟ୍ ସବମିଟ୍ ହେଇନି ସାର୍, ବର୍ଷେ ଅଲରେଡି ହେଇଗଲାଣି।
ସେଟା ଠିକ ଅଛି, ସେଟା ଆମେ କନସିଡର କରି ଆପଣଙ୍କ ବେଲ୍ ଆପ୍ଲିକେସନ ଶୁଣେଇଲେ କି କଣ କନସିଡର
ସାର୍
ସ୍ପିକିଂ ପ୍ଲିଜ କିପ୍ କ୍ୱାଇଟ୍। ଶୁଣନ୍ତୁ ଆଜ୍ଞା, ଆପଣଙ୍କର ଯାହା କହିବାର ଅଛି ବେଲ୍ ବିଷୟରେ ଆପଣ କହିବେ, କିନ୍ତୁ requires that the victim has to be heard. Now when the victim states that she is
not capable of hiring a lawyer, we are engaging somebody from the legal aid, that's all. So in which parents will pass this order? We will consider.
Short date କରନ୍ତୁ sir.
Shorted ହେଇପାରିବ, shorted ହେଇପାରିବ, ଯେତିକି ହେଇଛି ହେଇଛି. Yes, next matter.
Item 60.
May I please your lordship? The petitioner is in judicial custody since 14 June 2023. And he is alleged to have committed an offense under section 20B2C and 29 of NDPS Act, your lordship. It is alleged that the prosecution story is that the complainant got a reliable information from reliable source that Ashok Leland truck is coming.
920 kgs. Yes, what
Yes, lordship. But it was not seized from my conscious possession, and it is alleged that the person from whom it has been recovered, that is one Birendra Singh, your lordship. And he has identified only name of one Sankarshan Barik, that is at page 13 in the last part. If my lord permits me, I will place your lordship. Ganja, and confessed that he, along with Sankarshan Barik of Rudi Mahul PS Kantamar, at present Malpada Balangir, Prashant Kheti of Balangir, and driver of truck along with 4 unknown persons loaded in the Hyundai Venue car bearing registration number so and so were procured the ganja. Then
what is your name?
Your lordship, my name is Sunil Kumar Sahu and
Sunil and
Sarosh
Saroj.
Sangha.
Sunil and Saroj.
The names do not find place in the FIR?
No, madam. That only that occupant, Virendra Singh, who is the occupant of the trap, he only stated that he knows the 2 persons, Prashant and Sankarshan. And Prashant, Sankarshan, they were in that car, which car was fled away from the scene. Prashant disclosed the name of the present petitioners.
What is the role of the present petitioner according to Prasanta?
They were in that car and they were loaded the ganja in that truck. That was the addiction.
The petitioner is in custody since
14/6/23.
14/6/2023 in connection with such case. The prosecution case is that a truck containing contraband ganja weighing 920 kgs was spot or of his role in the alleged occurrence, including possession. As such, the ratio laid down in Tofan Singh versus so and so applies to the facts of the case. So, considering the above, I am inclined to allow the prayer for bail, that the petitioner be released, each their parents.
That's the petitioners.
The petitioners.
Item 63.
May I please your lordship on behalf of Ms. Nanda? Lord, this is a case under section 302 IPC. The occurrence is of 24th night, 25th morning, March 2023. Arrest is dated 8/4/2023, and the petitioner is in custody since 1 year now.
So, case date is there?
Yes, ma'am.
Yes.
The FIR was registered against unknown persons, and no eyewitnesses are there. No direct evidence is forthcoming. Lord, 33 charge sheeted witnesses are there. Only 5 have been examined so far. On the last date, my lord, on 6/4/2024, your lordship had asked to wait and some more time, and you had your lordship had specifically given this date. And in the meanwhile, no other charge sheeted witnesses have been examined.
Yes, who are the named witnesses?
The informant and
informant is
Ramba Dangi.
She's not an eyewitness?
No
eyewitness there.
What about the other material witness?
Another is that wife of the present petitioner who was seen that the present petitioner is going to the deceased house on that.
He specifically mentioned it to her that I'm going there. She is just all on suspicion.
My dear. And the wife of the petitioner. ମୋ ନାମ ଲିଲି ପ୍ରଧାନ ସ୍ୱୟଂ ମୁଁ ପାରାଦୀପରେ ମଜୁରୀ କାମ କରୁଥିବା ସମୟରେ ହରିହରପୁର ଗାଁର
ଗୋଖରା ସହ ପ୍ରେମ ସମ୍ପର୍କ ହେବାରୁ ସେ ମତେ ତାଙ୍କର ସ୍ତ୍ରୀ ରୂପେ ଗ୍ରହଣ କରିଥିଲେ। ତାଙ୍କର ପ୍ରଥମ ସ୍ତ୍ରୀ କାମିନୀ ଗୋଖରା ତରଫରୁ ଗୋଟେ ପୁଅ ଗୋଟେ ଝିଅ ଅଛି। ମୋର କିଷାନ ଜାତି ହୋଇଥିବାରୁ ମତେ ତାଙ୍କ ସମାଜରୁ ଅଲଗା କରିଦେଇଛନ୍ତି। ତେଣୁ ମୁଁ ମୋ ସ୍ୱାମୀ ସହ ତାଙ୍କର ଅଲଗା ଘରେ ରହୁଛି ଓ କୁଲି ମଜୁରି କରି ଚଳୁଛୁ। ଗତ ବର୍ଷ ତାର ଆଗ ସ୍ତ୍ରୀର ଝିଅ ସୁଷମା ଗୋଖରା ର ଦେହ ବହୁତ ଖରାପ ହେଲା ଓ ଡାକ୍ତର ଔଷଧ କାମ କଲାନି। ଦ୍ୟାଟ ଇଜ ରିଲେଟିଂ ଟୁ ମାନେ ୱିଚକ୍ରାଫ୍ଟ ଯେହେତୁ ଆମ ଗାଁର ଯୋଗୀନ୍ଦ୍ରନାଥ ଆମ ମଝିଆ ଭାଇ ଅଲେଖ ଗୋଖରାର ଝିଅକୁ ପାଙ୍ଗିଥିଲା, ତେଣୁ ସେ ସ୍ୱାମୀ ସନ୍ଦେହ କଲେ ଯେ ସୁଷମାକୁ ମଧ୍ୟ ଗୁଣିଗାରେଡ଼ି କରିଛି ବୋଲି। ତେଣୁ ମୋ ସ୍ୱାମୀ ଝିଅକୁ ତାନ୍ତ୍ରିକ ବାବାକୁ ଦେଖେଇ କୃଷ୍ଣଙ୍କୁ ପୂଜା କରି ଝିଅକୁ ଠିକ କରିଥିଲା, ଯାହା ଫଳରେ ତାଙ୍କର ପ୍ରାୟ 1 ରୁ 1.5 ଲକ୍ଷ ଟଙ୍କା ଖର୍ଚ୍ଚ ହୋଇଥିଲା। କିଛି ଦିନ ପରେ ମୋର ସ୍ୱାମୀଙ୍କର ବାରମ୍ବାର ଦେହ ଖରାପ ହେଲା ଏବଂ କୌଣସି କାମଧନ୍ଦା କରିପାରିଲେନି। ଏହାପରେ ସେ ଯୋଗୀ ସହ ମିଶୁଥିଲା ଓ ତା ବିଷୟରେ ଖବର ନଉଥିଲା। ଯୋଗୀ ଇଜ ଦ ଡିସିଷ୍ଟ ମ୍ୟାଡମ। ସେ ଆଉ ଥରେ ଯେମିତି ଆମ ପରିବାରକୁ ଗୁଣିଗାରେଡ଼ି କରି ଆଉ ହଇରାଣ କରିବ ନାହିଁ। ଏହାପରେ ମୋ ସ୍ୱାମୀଙ୍କର ବହୁତ ପଇସା ପତ୍ର ଅସୁବିଧା ହେବାରୁ ମୋ ସ୍ୱାମୀ ଯୋଗୀ ଠାରୁ 10,000 ଟଙ୍କା ଧାର ଆଣିଥିଲେ ବେପାର କରିବା ପାଇଁ। ଏହାର କିଛି ଦିନ ପରେ ଯୋଗୀ ହନୁମାନ ପଇସା କାରବାର କରି ଗତ ସେପ୍ଟେମ୍ବର ମାସରେ ରିଆମାଳ ଥାନାରୁ ଗିରଫ ହୋଇ ଜେଲ ଯାଇଥିଲା। ଗତ ଜାନୁଆରୀ ମାସରେ ଜେଲରୁ ଆସିବା ପରେ ଯୋଗୀ ମୋ ସ୍ୱାମୀକୁ ବାରମ୍ବାର ଟଙ୍କା ମାଗୁଥିଲା। ମୋର ସ୍ୱାମୀ ଆମ ଘରେ ନଥିବା ବେଳେ ମଧ୍ୟ ଯୋଗୀ ବାହାନା କରି ବାରମ୍ବାର ଟଙ୍କା ମାଗିବାକୁ ଆସେ। ସେଥିପାଇଁ ମୋ ସ୍ୱାମୀର ଯୋଗୀ ଉପରେ ବହୁତ ରାଗ ଥିଲା, କାରଣ ଯୋଗୀ ପାଇଁ ମୋ ସ୍ୱାମୀର ଓ ଝିଅର ଦେହ ଖରାପ ହେବାରୁ ଆମର ପ୍ରାୟ 1 ଲକ୍ଷରୁ 1.5 ଲକ୍ଷ ଟଙ୍କା ଖର୍ଚ୍ଚ ହୋଇଥିଲା। ଏଇ ସବୁ ରାଗରୁ ମୋ ସ୍ୱାମୀ ଗୋଲେକ ଗୋରଖା ତାକୁ ଉଚିତ ଶିକ୍ଷା ଦେବା ପାଇଁ ମନ ଭିତରେ ରଖିଥିଲା। 24 ତାରିଖ ଦିନ ଆମ ଗାଁ ପାଖ କଖାରୁମାଳରେ ଅଷ୍ଟପ୍ରହରୀ ନାମଯଜ୍ଞ ହଉଥିଲା। ସନ୍ଧ୍ୟାରେ ମୁଁ ଓ ମୋର ସ୍ୱାମୀ ନାମଯଜ୍ଞ ଦେଖିବା ପାଇଁ ଗଲୁ। 8:30ରୁ 7ଟାରୁ 8ଟା ଭିତରେ ଆମେ ନାମଯଜ୍ଞରୁ ଘରକୁ ଫେରିଲୁ। ଯୋଗୀନ୍ଦ୍ର ମଧ୍ୟ ନାମଯଜ୍ଞ ଦେଖିବାକୁ ଯାଇଥିଲା। ମତେ ଘରେ ଛାଡିଦେବା ପରେ ମୋର ସ୍ୱାମୀ ଯୋଗୀ ଘର ସାହି ଆଡେ ଗଲେ। Only she has seen my lord.
ଯୋଗୀ ଘର ସାହିଆଡେ ଗଲେ କୁଆଡେ ଗଲେ ସେ କଣ ଦେଖିଛନ୍ତି? ତାପରେ ଆଉ କଣ?
ଆଉ then informant his statement is that my lord.
Informant ତ ଦେଖିନି
no one has seen my
At all, my lord. Circumstantial evidence is also not.
ଆଉ recovery
my lord, that blood stain acts it was seized from the storeroom of the present petition.
blood stain acts. Was there any cross matching of the blood group?
Nothing.
My lord, that was sent to his
official report.
Your statement is not forthcoming.
Disclosure statement
Is not forthcoming. There is nothing, my lord. In fact, the charge sheet says that it was a bloodstained knife, whereas the 2 independent witnesses say that he confessed that he went to the nearby Anganwadi and washed his hands and the axe. So it is strange how bloodstained axe was discovered at all, and the discovery was made after 10 days. So
my lord, that your lordship directed to take instruction that SFSL report. And SFSL report has not yet come. They have also given a written instruction that it will be noted that exemption will be taken up on priority basis. That was a letter received from the SFSL. And that leading to discovery matter that bloodstained axe was seized from the store or room of the present victim.
reduced to writing anywhere that has not been recorded by the police. Only the
27 statement is not there.
Yes, madam.
There is a 27 statement.
Yes, madam.
Yes. ମତେ ମୋର ଘରକୁ ନେଲେ ମୁଁ ଲୁଚାଇ ରଖିଥିବା ବାଉଁଶ ଧାନ ଡୋଲି ପଛପଟରୁ ଟାଙ୍ଗିଆ ଓ ଘଟଣା ସମୟରେ ପିନ୍ଧିଥିବା ଧଳା ଫୁଲ ସାର୍ଟ କଳା ଫୁଲ ପ୍ୟାଣ୍ଟ ଓ ଚେକ୍ ଗାମୁଛାକୁ ଶୋଇବା ଘର ଅନୁଗୁଳି ଭିତରୁ ବାହାର କରି ଦେଖାଇଦେବି। There is a statement. How do you say that there is not a statement? There is no statement.
perhaps it is.
You have not gone through the police papers.
Perhaps it is not in my record. My lord. I
How
apologize.
come you have not gone through you have the entire police papers with you?
Not sure. My lord, if you may kindly see the charge sheet, my lord, it has been mentioned that one axe was discovered with a blood stain, and the independent witnesses, whoever have these two, my lord, Duryodhan Rana and Ajay Kumar Naik, both have stated that the confession contained the confession was that I washed my hands and the axe.
That is immaterial. That is not admissible. Whatever they may have confessed, that is inadmissible. But the recovery of the acts, the statement leading to discovery of the acts.
My lord, all of these co-villagers are farmers. Just mere finding an axe may not be sufficient evidence.
No. If the axe contact, you see, the axe was found being concealed in a house.
Storeroom, my lord. In the house of the
ଲୁଚାଇ ରଖିଥିବା ବାଉଁଶ ଧାନ ଡୋଲି ପଛପଟରୁ ଟାଙ୍ଗିଆ ଓ ଘଟଣା ସମୟରେ ପିନ୍ଧିଥିବା ଧଳା ଫୁଲ ସାର୍ଟ ଓ କଳା ଫୁଲ ପ୍ୟାଣ୍ଟ ଓ ଚେକ୍ ଗାମୁଛାକୁ ସୁରକ୍ଷା ଘର ଅନୁଗୁଳି ଭିତରୁ ବାହାର କରି ଦେଖେଇଛି. This is the entire, you have to read it in whole. What about that cross matching has not been done?
No, that report has not been.
examination report is also.
You think it should
Application lordship directed, but I have informed the police. Police also send one person.
matching has to be done? Blood will be to the go to the number.
But they are pending. Many cases are pending in SFSL.
Yes.
Lordship may pass an order, I would immediately a free copy, or lordship may give in a free copy. That on that basis, I think that.
No, even assuming for a moment that this is the only evidence.
This is the only evidence. Once I seen also that maybe.
Clearly say, just wait.
My apologies.
Why are you being so anxious? The wife doesn't say in the specific, there's nothing specific. She simply says that ମୁଁ ଦେଖିଲି ସେ ତାଙ୍କ ଘର ଆଡେ ଗଲେ ଗଲେ କି କୁଆଡେ ଗଲେ କି ଜାଣିଲ ତମେ?
That is only allegation. And only that leading to this.
No, we grant that. The petitioner is in custody since
1 year, my lord. My lord, just
1 year.
My lord, 8/4/2023.
8/4/2023 in connection with such case. The prosecution case is that an unknown culprit entered into the house of the deceased Jogindra Nag and committed his murder by means of an axe. In course of investigation, it came to light that the petitioner had a dispute with Jogindra Nag related as he suspected Jogindra of practicing witchcraft.
Yes.
Further, he had also borrowed some money from Jogindra. On such basis, it has been alleged that taking advantage of the presence of Jogindra in his house alone, the petitioner entered and brutally assaulted him by means of an axe, causing his death. Learned counsel for the petitioner submits that there is no eyewitness, there are no eyewitnesses to the occurrence. And the case is based on suspicion only. Stop. Learned State Counsel, while opposing the prayer for bail, submits that the petitioner gave recovery of the axe used in the occurrence along with the wearing apparel, along with his wearing apparel, which he had concealed in the storeroom of his house. He further refers to the statement of the petitioner's wife, namely Lily Pradhan, who stated that the petitioner had visited the house of the deceased prior to the occurrence. So, after hearing learned counsel for the parties and on going through the materials available in the case diary, this court finds that the statement of Lily Pradhan is to the effect that the petitioner left her in their house and thereafter went towards the locality of locality in which the house of the deceased is situated. She does not specifically say that the petitioner had visited the house of the deceased. There is no other evidence to show the complicity of the petitioner in the alleged occurrence, save and except his statement recorded under section 27 of the Indian Evidence Act. It is trite that a conviction cannot be recorded only on the basis of the disclosure statement. Taking into consideration all the above facts, as also the period of detention and custody, I am inclined to allow them to each day custody.
I don't think proposed.
May it please your lordships. Your lordships, petitioner earlier approached this honorable court by the anticipatory bail. In pursuant to order of the anticipatory bail, he was surrendered before the honorable court below on 6/11/2023, and since then he is behind the custody, your lordships. The charge sheet
Surrender certificate.
surrender certificate.
This is a regular bail.
It's a regular bail. It's the regular.
What surrender certificate?
Earlier he was on 18.
Interim bail, your lordships. After I have to surrender, your lordships.
You have the surrender certificate?
Yes, sir. After this is the surrender certificate.
We'll hear the main application. KY surrender consent.
19/1 for us.
Surrender certificate is filed in the court today, indicating that the petitioner has surrendered to custody on 19/1/2024 after expiry of the interim bail granted by this court. Same be kept on record.
Your lordships, charge sheet.
The bail application is Ashwini Sandhu. Sandhu alias
Shyam Kedia like Cherry.
Sam Khadia. Date of arrest. Inshallah.
As regards TI period, I am saying that before that, before the conduct of the TI
Both were
period,
correctly identified. Yes.
before the conduct of the TI period, on 11/4/2023, if you look into the seizure list, in which seizure witness Judge Ketan Pradhan and Gauri Shankar Deori are witnesses, the photograph of the accused were taken by one photographer as per the direction of the police, and that was circulated. And another thing is that on 10/4/2023, Pavitra Naik 161 statement discloses that the accused was brought by the police and the accused admitted to have committed the crime and demonstrate how they have committed it. But if
The officer conducting the TI parade writes that identifying witness had not been given any chance to see the suspects before TI parade. Now, if it is your case that a photograph had been circulated, then it is to. So, if it is your case that the photograph was circulated, then you have to bring it to the notice of the court about the sanctity of this TI parade. This court cannot decide the matter here. It is for the court below. Let the court below. I will record it. I will say the court below. If such an application is filed, the court below may conduct an inquiry.
Occasion he stated that they were not identified. Now he said therefore your lordship for the TI parade. Now he is saying that he was earlier.
And before that, they were produced by the police.
No, how can this court come to a finding without any inquiry?
Now, if you look into the material on record,
What material? Why will I disbelieve my officer when my officer writes that identifying witness had not been given any chance to see the suspects before TI parade? They are making an allegation. If you have any material, raise it before the court below. The court below will conduct an inquiry.
We'll find out whether the police had actually shown him the photograph or not. But that will not entitle you to bail.
That is the 161 statement of the witness.
Yes, let us see that. Yes.
Who is a witness to the TI parade.
Hmm.
Before him, the accused person was brought by the police, and they were shot. And
What is the allegation?
My lord, there is 302 unknown FR was lost.
Yes.
He is the deceased is the employee of an financing company, my lord. When she came out, these two persons, they came in a bike and they cut the throat of the deceased. That Vibhuti Bhushan Samantrai was seen that two person who was identified in the accused person in the DI parade. And that knife also seized from the spot. And some employees also, they tried to rescue the deceased, but they were the petitioners were fed away from the spot.
But they have not identified. They only say that they were running.
You go through the TI parade report.
Apart from that, no one.
We'll take it up. I am passing it over. We'll take it up. Let the State Council go through the TI parade report.
I have gone through the TI parade report. So
no, let the State Council go through. We'll see.
To counter it, apart from that, sir, no what act has been attributed particularly to this accused. And
Yes, that I will consider. Don't worry, I will consider.
Yes. Will rely more on human probability.
All right, pass over.
Item 66.
All right, pass over.
On behalf of SK and the amendment permitted to place the matter, madam. Here the present petitioner is the mother-in-law being implicated under section 498A 306.
Postmortem report.
Postmortem.
Along the case. What does it say? Tell me. After 1 week of marriage, the in-laws of Kavita Sahu tortured her physically and mentally, demanding more dowry.
It was preserved for viscera.
Report दिया नहीं, मैंने opinion दी ना थी.
नहीं.
What is the external injury? What is the inquest report?
There is there is no such only ligature mark is there. There is no such injury. And only allegation is that the present petition is the mother-in-law. Anticipatory bail of the husband, it was allowed, and mother-in-law was it was rejected. Then, my lord, the marriage one is in 7/7/22. Incident took place on 6/10/22. Within 3 months, the allegation is that torture and dowry demand 1 lakh and 1 motorcycle, and there is motorcycle.
Material? How did the husband's application be allowed?
It's not present on the spot. That is in anticipatory bail was allowed. And my lord, to complainant, who is the brother, his statement is that, my lord, a relevant part I am reading. जे मोर उपर भूणी कविता साहू को आम मिर्जापुर ग्रामर प्रफुल्ल सामल पुओ प्रभाकर सामल को यही वर्ष जुलाई 6 तारिख में वैध रीति में बुद्धलिंग मंदिर में विवाह कराई विवाह समय 50,000 टंका जानी ज्योति को आशीर्वाद मध्य दिया बाहागर 1 मास पर मो भौणी शाशु और भिणे विभिन्न प्रकार आड़ देखा गोटे गाड़ी और 50,000 टंका पाई विभिन्न प्रकार मानसिक जंत्रणा दियंती और गाड़ी गुलो सहित मारपिट करती मो भौणी आम घरे फोन करी कहितला मो भौणी को मारपिट करिसेंती जानिला परे मो बापा सहित मो भौणी घरे पहुंची तार शाशु को बुझासुझा कलु मो बापा मो भौणी शाशु कहले समुद्री मो पाखे एबे पैसा नहीं मो पाखे पैसा ले आपण मो झील को कहिथिबा जिनिस पत्र देबी मते 2-3 मास समय दियंतु या पर आमे घरु फेरी आसिलु आम ग्राम कुमार पूर्णिमा लक्ष्मी पूजा हो मो भौणी को डाकिथिलु किंतु भौणी कहिला मु जाई परिबि नै मते शाशु मना करछन हठात अक्टोबर 5 तारिख राति 2022 राति 10 टारे भौणीर शाशु मोबाइल फोन रु ताको पड़िसा घर लोक फोन करी कहले जे तम झील कौन फांसी देइछि तुमे सांगे सांगे आस एक कथा सुनी आमे परिवार लोक मिर्जापुर पहुंचे
पड़िसा घर लोक पढ़िले कोन अछि
देन माय लॉर्ड विलेजर वन नेबर माय लॉर्ड हिज स्टेटमेंट आमे कहबा चाहू कि मिर्जापुर ग्रामर प्रफुल्ल साहू प्रभाकर साहूर विवाह पटनिया ग्रामर कविता साहू सहित एक वर्ष जुलाई 6 तारिख में वैदिक रीति में बुद्धलिंग मंदिर होता बाहागर 15 कि 20 दिन पर प्रभाकर हैदराबाद को काम करने को पड़ता प्रभाकर साहू घरे तार बोऊ भारती साहू स्त्री कविता और भणजा विश्वजित साहू रोते बोऊ शाशु बोऊ भितर सब छोट छोट कथा नहीं झगड़ा लगे और पुणी समाधान हुए 5/10/22 दिन प्रभाकर बोऊ भारती साहू और स्त्री कविता साहू भितर झगड़ा लगी प्रभाकर स्त्री कविता शोइबा घरे पशि भीतर पटू कबाट बंद कर ପ୍ରଭାକର ବୋଉ ମତେ ଡାକିଲେ କି ଯେ କବାଟ ଖୋଲିଲେନି, ତେଣୁ ପ୍ରଭାକର ବୋଉ ଭାରତୀ ସାହୁ ଆମ ଗ୍ରାମରେ ଥିବା ଲୋକମାନଙ୍କୁ ଡାକିଲେ। ଆମେ ଗ୍ରାମର କିଛି ଲୋକମାନେ ମିଶି ପ୍ରଭାକର ଶୋଇବା ଘର କବାଟ ଭାଙ୍ଗି ଭିତରେ ପଶି ଦେଖିଲୁ ଯେ ପ୍ରଭାକର ସ୍ତ୍ରୀ କବିତା ସାହୁ ଫ୍ୟାନରେ ତାର ପିନ୍ଧା ଲୁଗା ପିନ୍ଧି ଆତ୍ମହତ୍ୟା କରିଛି। Within 3 months, she has
There is an allegation of dowry torture.
dowry torture. A
Yes.
specific allegation against the mother-in-law.
Yes.
Because
The brother what my lord is senior first read my lord, he is the informant my lord, brother. If allegation is there my lord, then he has not whispered a single word in the FIR my lord. And next thing my lord, even if accepted that they have
Did they change? The 161 is at variance from the FIR.
totally changed my lord.
What is the FIR that is in the FIR?
see that FIR.
FIR kahin?
Is at page 8 my lord.
Page 8 ta kola. Page 7.9 baharan. Pass it on.
এটা ବି
ये ठीक अलग ही नहीं, इसलिए भी नहीं.
সেটা ক্লিয়ার হচ্ছে।
হ্যাঁ এটা কি
But first take a paragraph.
ବିବାହର 1 ସପ୍ତାହ ପରେ ଝିଅ ଘରକୁ ବାରମ୍ବାର ଫୋନ କରି କହେ ଯେ ମତେ ଅଧିକ ନିର୍ଯାତନା ଦିଆଯାଉଛି, ସେ ସବୁବେଳେ ମାନସିକ ଭାରାକ୍ରାନ୍ତ ରହୁଥିଲା ଓ ତାକୁ ମାଡ଼ ଗାଳି ଦିଅନ୍ତି ବୋଲି ସେ ଫୋନରେ ଅନେକ ଥର କହିଛି। ଆଉ କଣ କହିଥାନ୍ତି?
But what they have stated that they have demanded 50,000 and they have gone to the house of the petitioner.
50,000 ଲେଖି ପାରୁନାହାନ୍ତି ଆଉ।
No man, they have stated that they settle the matter, they will fulfill the demand after 2 to 3 months my lord. But if after that this is committed suicide my lord, we have to sin that regard my lord.
You renew your prayer after examination of this Pramod Kumar Sahu. Renew your prayer.
A 54-year-old my lord, last 6 months he is in custody my lord.
हाँ हो कहाँ है सब? अरे 302 कौन खबर है?
306.
306 हो तो 302 बाहर से 306
306
Prime office
304 भी अच्छी
yes my lord.
302 छाड़ दो 304 भी अच्छी
But demand of dowry not clearly established my lord.
no you are true, you are correct,
Aspect
you are correct,
so they are after 3
you are correct. If you only the FIR allegation is read, then it may appear slightly appear to be omnibus, but then why will you tell me, you give me a reason why this person will make an allegation against you, and you being a member of the family, and this is a 304B, a presumption of it, so it is a burden is also on you to show why did she commit suicide? Her husband was not there, you alone were there.
That as per my instruction that they have the deceased was not agreed to marry my lord, so they have some different issue.
So she would have done that immediately. 3 months, why will she wait? Renew your prayer after examination of this Pramod Kumar Sahu.
Pramod and Jagabandhu.
Yes. Withdraw it. Land counsel for the petitioner seeks permission to withdraw the bail application with liberty to renew his prayer after examination of the informant Pramod Kumar Sahu and
Jagabandhu.
witness Jagabandhu Sahu. Permission is granted with liberty as aforesaid.
67.
May I please endorse? Charge sheet submitted, my lord. 147, 148, 341, 302, 120B, 149 of the IPC. Petitioner are in custody, my lord, since 21, 123.
All the accused persons are petitioners here? No, some.
Some 4 here and another, my lord, 53.
The item 53 or the 4 petitions of the
Item?
all the accused involved.
Item कितना पहले?
Item 53. There are 4 petitions.
Nine, pending. One statement. कोई सर
Cool.
So ସମସ୍ତେ ମିଶିକି ମାରିଲେ? That is the allegation.
ଆଜ୍ଞା.
When Duryodhana Gowda and Jagannath Gowda reached the zone shifted to High Court Medical College Anganwadi. Village Talsara company. So because of prior enmity, they formed an unlawful assembly and they killed this allegation.
They followed them. No one seen, my lord.
No, that's all right. That is an allegation.
That is there is a 2 group in the village, my lord. For regarding that presidency of the village, there is the petitioner group acts to the informant group to give that monetary transaction. Thereafter, there is a hot exchange of word between them, my lord. Thereafter, there is a case and counter case and against each other. Again on as per FIR story, my lord, on 21/1/23, when the Pankaj Gowda came in a motorcycle, all on a sudden the petitioner saw them and they were followed. As per statement of one Samir Gowda, my lord, I am read it out that Gauranga Dharithiba relevant portion. Gaurang Dharithiba gotiye bounce ठेंगा ता मुंडो को जोरे बाड़े देला भागीरथी गौड़ गोटे पत्थर रे मो मामू मुंडो को छेची देला अन्य माने मध्य समस्ते मुंडो को पत्थर रे छेची देले मो मामू रो मुंडो फाटी रक्त बाहरिला से मरीगला भाभी से धरिदिया बाउंस ठेंगाटी को रागपुर गाँ बालीबण साई कोठघर पछपटे नटी भीतर लुचाई दे धाई की पलाई गला आज्ञा
गौरांग कथा कहूँ
आज्ञा गौरांग बाड़ेला भागीरथी पत्थर रे छेची देला बोली कहूँ एंड दैट इन 27 my lord that was recovered from गौरांग that weapon of offense that is lathi, my lord.
All right.
And in the meantime, charge sheet submitted, custody, my lord, since.
So that is the only statement of eyewitness. Any other eyewitnesses?
Other stated they have followed, not seen any.
No, any other eyewitness?
So far as another. Deborah Sethi, my lord. हठात 6-7 जन लोक कि ताठू अधिक हे मु कहि परनी सेही मोटरसाइकल आसुथिबा बेले लोकटी गाड़ी गुलज करी पार्टी करी मारिया पई तोड़िले एहा देखि कोन हैला बोली भाबी मु छक पाकू आसी देखिली जे बालीबण साई रास्ता रे सेही लोक माने सेही मोटरसाइकल रे आसुथिबा लोकटी को तळे पकाई इटा बाउंस बाड़ी ओ बाड़ी रे पिटुचंदी एही समय रे किछि लोक एठारे गहळी होई जिवारु सेही मारुथिबा लोकटी लोक माने सेठारु पळाइले किंतु तळे पडिथिबा लोकटर मुंड फाटी प्रबल रक्त बाहरुतिला मु सेठारे पचेरिबारु जानिबाकू पाइली जे से माने भाबिनीपुर गाँ रो लोक जेउ लोक माने मारुथिले सेमानक भितरे बालीबण गाँ रे डाक गौड़र 2 जन सोळा मध्य जहांकर नाम प्रभाकर गौड़ प्रकाश गौड़ माड़ खाइथिबा लोकर नाम पंकज गौड़ बोली मु लोक ठारु जानिली किछि समय परे एठारे एम्बुलेंस अछि पहुंचिला
नला ओके एदी आंसर
Biranchi Gowda was accompanied the deceased madam.
Biranchi Gowda and Sushant Gowda.
से कहला रेलिवेंट पोर्शन
की
जो बिरंची गौड़ एमाने पंकज पथरे धाई की बालीबण साही रास्ता उपरे ठेंगा पत्थर बाउंस बाड़ी रे पंकज को पिटी पिटी मुंड फटाई देले एहा देखी मु सुशांत भयरे सेठरो पळाइलु दैट इज द स्टेटमेंट
की बडले
कि समस्या आगुरु कहछि समस्त मो पंकज रो सांग सुशांत गौड़ ता मोटरसाइकल रे बेगुनिया पड़ा जाउथलो आमे रागपुर आदर्श स्कूल पाखरे पहुंचा बेले पंकज बालीबण छकर पाखरे पहुंचला सेटारे आगो आम गाँर भागीरथी गौड़ भरत गौड़ विनायक साहू प्रभाकर गौड़ प्रकाश गौड़ गौरांग गौड़ और कालू गौड़ आगुरु थिले सेमानको सहित आउ किछि लोक रहिला बळी लागुतला कारण सेही जगह टिके अधिक गहଳି थिला सेमाने पंकज को बालीबण छक पाखरे अटकाई ताकू गाली गुलज करी मारपीट करिया धाइले या देखि आमे मते सेटाও गलु पंकज सेमानो देखि ता मोटरसाइकल पकाई दे बालीबण साही भितर को धाइकी पळाइला किंतु एमाने पंकज पत्रे झाइकी बालीबण साही भितर रास्ता उपरे ठेंगा पत्थर बाउंस बाड़ी पंकज को पिटी पिटी मुंड फटै देले या देखि मु सुशांत भयरे सेटारु पळाइ आसिलु and that broken piece of bricks and bamboo stick it was seized from the spot and the PM report is cerebral injuries so pity down 12 numbers of injuries are there
12 number of injuries on the head
no head dita other body re and that he was recovered from Gaurang
is your
yes
friend
all 7 persons are in the
Gaurang
Prakash Gowda and in the item 63 also.
No, 53 re.
53 is your matter.
Yes, sir.
That has been passed over. That Prabhakar denied. No, the first statement that you read of with some witness, who is he?
That is Samir Gowda.
They are not the eyewitness to the occurrence.
ନାଇଁ ସେ କହିଲା ପରା
Two eyewitnesses, one Bironchi.
ଏହାପରେ ସମସ୍ତ
No, ମୁଁ ଟିକେ ପଢିଲି ସେ ତାର ସ୍ପଟ ପ୍ରେଜେନ୍ସ ଟା ଆମେ ଜାଣିବାକୁ ଚାହୁଁଛୁ।
relevant portion ଟା ମୂଳରୁ
I want to know whether he was which assaulted, which person assaulted by means of a stone. It's consistent with the postmortem report also.
ଠେଙ୍ଗା ପଥର ବାଉଁଶ ବାଡି ଗୁରୁଣି
ଠେଙ୍ଗା ମୁଁ ପଚାରୁଛି 7 ଜଣ ଯଦି ବାଡେଇଛନ୍ତି 7 ଠେଙ୍ଗା ତ ଥିବା ଦରକାର।
ଲସି and thereafter ଲସି they also
ନାଇଁ ସେଇଟା ଆଗ ଆନ୍ସର ଦିଅନ୍ତୁ ତାପରେ ଯିବା
ଲସି
ମୁଁ ଟିକେ ଆଜ୍ଞା ସ୍ଲୋ ବୁଝିବାକୁ ମତେ ଟିକେ ଟାଇମ ଲାଗିବ ତେଣୁ ଆପଣଙ୍କ ଭଳିଆ ଏତେ ଫାଷ୍ଟ ଯାଇପାରିବେନି।
ଗୁଡାଏ ସିଜ ସବୁ ସମସ୍ତଙ୍କୁ ସିଜ ହେଇଥିଲା
ସମସ୍ତଙ୍କୁ ଯଦି ଗୋଟେ ଗୋଟେ ଠେଙ୍ଗା ସିଜ ହେଇଛି କୁହନ୍ତୁ। that must be very significant.
ଲସି ଭରତ ଗୌଡ଼
ଆପଣ ପ୍ରିପେୟାର କରିନାହାନ୍ତି
ବିନାୟକ ସାହୁ ପ୍ରଭାକର ଗୌଡ଼
କଣ ସିଜ ହେଇଛି ପ୍ଲିଜ ଫାଇଣ୍ଡ ଆଉଟ୍। ମିଛ ମିଛ
this is the entire seizure list, your lords.
That happened, there was also the threat reception. After the incident, the FIR also lodged against the petition.
From whom seized? ଗୌରାଙ୍ଗ କହୁଛି ଗୋଟେ ବାଉଁଶ ବାଡି ରକ୍ତ ଲାଗିଥାଏ ଗଲା ତାପରେ from whom seized ବିନାୟକ ସାହୁ ଏଥିରେ ନାହିଁ ତାଙ୍କ ପାଖକୁ କେବଳ ତାଙ୍କର ୱେରିଂ ଆପାରେଲ ବାଉଁଶ ସିଜ ହେଇଛି କେବଳ ଗୌରାଙ୍ଗ ନା ପଥର
spot ରହିଛି
ବାଉଁଶଟା ଖାଲି ଫିଙ୍ଗି ଦେଇଥିଲା ସେ ବାହାର ଜାଗାରେ
bamboo sticks, broken piece of bricks, bamboos, it was seized from the
କାହିଁ ସେଟା କୋଉଠି ସିଜର ଲିଷ୍ଟ କାହିଁ
spot.
ସ୍ପଟରୁ କଣ ସିଜ ହେଇଛି କୁହନ୍ତୁ
Broken piece of bricks and bamboo sticks.
ବାଉଁଶ କେତେଟା
ସେ ଖାଲି ଲେଖିଛନ୍ତି bamboo sticks.
ସେମିତି କେମିତି ହବ police is preparing a seizure list. Seizure list has some columns.
Seizure list bamboo stick was seized from Gowrango. From the spot there is
so ସମସ୍ତେ ତ କେମିତି
ଠେଙ୍ଗା ସମସ୍ତେ specific allegation all are assaulted.
ଶୁଣନ୍ତୁ ଭାଗୀରଥୀ ଗୌଡ଼ and ଗୌରାଙ୍ଗ whatever his name rejected ବାକି others
ଖାଲି ଭାଗୀରଥୀ ନାହିଁ ଭାଗୀରଥୀ ଗୌରାଙ୍ଗ ଭରତ Person kindly ask what happened in the present case. Person kindly go through the backdrop of the case.
No backdrop नहीं आपने सीधे evidence backdrop को कौन हो
ମାନେ ଗୋଟେ ଲୋକକୁ ଡରିକି ଜଣେ ଲୋକ ଗାଁ ଛାଡ଼ିଦେଲା ତଥାପି ସେମାନେ ତାକୁ they have misappropriated the village fund. Village fund is the public fund of the villagers. The subscription is collected from the villagers. And
Mr. Mahathi, you are a very experienced lawyer. Why are you taking the court towards that motive? There is direct evidence. How is motive relevant?
Seizure to
Seizure what seizure list by itself proves nothing. It connects, it corroborates the version of a particular item.
Postmortem report not a single blow, there are the 14 injuries, external 14 injuries.
The same person could have done it.
Can I say these are not child? In fact, they have explained the 4 numbers of the
So you say Bhagirathi Gowda is involved, Gauranga is involved. What about others? Tell me.
Others Prabhakar and Prakash.
What they have done?
Whom the eyewitness has identified.
What did he say?
He said that ଯେଉଁ ଲୋକମାନେ ମାରୁଥିଲେ ସେମାନଙ୍କ ଭିତରେ ବାଲିବଣ ଗାଁର ଡାକ ଗୌଡ଼ର 2 ଜଣ ଶଳା ମଧ୍ୟ ଥିଲେ ସେମାନଙ୍କ ନାମ ପ୍ରଭାକର ଗୌଡ଼ ପ୍ରକାଶ ଗୌଡ଼
and Prakash Gowda. But if you read that person's statement, it is very, very difficult to believe. Because in the beginning, as you have read out, if I remember correctly, he said that I don't know ଅଜଣା ଲୋକମାନେ ବାଡଉଥିଲେ ତାପରେ ସେ ସେଠି ଭେରିଫାଇ କରିଦେଲା ସାଙ୍ଗେ ସାଙ୍ଗେ କାହାର ଶଳା ସେ
ପ୍ରଥମରୁ କହିଲା ମୋଟରସାଇକେଲ ଆସୁଥିବା ଲୋକଟିକୁ ତଳେ ପକାଇ ଇଟା ବାଉଁଶରେ
କିଏ ଜାଣିନି Assailants କେହି ଜାଣିନି।
ନାଇଁ ସେଇ ସମୟରେ କିଛି ଲୋକ ଗହଳି ହେଇଥିବାରୁ ସେ ମାରୁଥିବା ଲୋକମାନେ ସେଠାରୁ ପଳେଇଲେ କିନ୍ତୁ ତଳେ ପଡିଥିବା ଲୋକଟା ମୁଣ୍ଡ ଫାଟି ପ୍ରବଳ ରକ୍ତ ବାହାରୁଥିଲା। ମୁଁ ସେଠାରେ ପଚାରିବାକୁ ଜାଣିଗଲୁ ପାଇଲି ଯେ ସମସ୍ତ ଗାଁର ଲୋକ।
କାହାକୁ ପଚାରିଲା? Consider it discreetly. It is prepared by the IO. All right. You look at it dispassionately. Does it inspire confidence? Even if he says this thing in the court. So the question that can be asked in cross-examination, from whom did you? Because initially you say that କିଛି ଲୋକ ଅଜଣା ଲୋକ ବାଡଉଥିଲେ। କାହାକୁ ବାଡଉଥିଲେ? ନା ସେ କହିବ ମୁଁ ଜାଣିନି। ତାପରେ ହଠାତ୍ ସେକେଣ୍ଡ ସେଣ୍ଟେନ୍ସ ସେ କହୁଛି ମୁଁ ସମସ୍ତଙ୍କୁ ଜାଣିଛି। ସେ ବୁଝିଥିଲି। ବୁଝିକି ସେ କଣ ଟିପା ଖାତାରେ କହି ବୁଝିଲା ଭାଇ ସେ ଯିଏ ବାଡଉଥିଲା ସେ ଲୋକ କିଏ ଏ ଲୋକ ତାର କେମିତି ଅନବିଲିଭେବଲ କଥାଟା କହିଲି କେମିତି ହବ?
କିନ୍ତୁ ଏଇ ଯୋଉ ବିରଞ୍ଚି ଗୌଡ଼ ଯୋଉ କହିଛି ଯେ ମୁଁ ଦେଖିଲି।
ହଁ ବିରଞ୍ଚି ଗୌଡ଼ କଣ କହିଛି ସେଟା କହ।
ବିରଞ୍ଚି ଗୌଡ଼ କହିଲା ତ ମୁଁ ତା ମୋଟର ସାଇକେଲ ଗଲି ତାପରେ ପଛେ ପଛେ ଗଲି। ସେଠାରୁ ଆମ ଗାଁର ଭାଗୀରଥୀ ଗୌଡ଼, ଭରତ ଗୌଡ଼, ବିନାୟକ ସାହୁ, ପ୍ରଭାକର ଗୌଡ଼, ପ୍ରକାଶ ଗୌଡ଼ ଏବଂ ଗୌରାଙ୍ଗ ଗୌଡ଼ କାଳୁ ଆଗରୁ ଥିଲେ। ସେମାନଙ୍କ ସହିତ ଆଉ କିଛି ଲୋକ ରହିଲା ବୋଲି ଲାଗୁଥିଲା କାରଣ ସେଇ ଜାଗା ଟିକେ ଗହଳି ଥିଲା। ସେମାନେ ପଙ୍କଜକୁ ବାଲିବଣ ଛକ ପାଖରେ ଅଟକାଇ ତାକୁ ଗାଳି ଗୁଲଜ କରି ମାରପିଟ କରିବାକୁ ଧାଇଁଲେ। ଏହା ଦେଖି ଆମେ ମଧ୍ୟ ସେଠାକୁ ଗଲୁ। ପଙ୍କଜ ସେମାନଙ୍କୁ ଦେଖି ତା ମୋଟର ସାଇକେଲ ପକାଇ ଦେଇ ବାଲିବଣ ସାହି ଭିତରକୁ ଧାଇଁ ପଳାଇଲେ। କିନ୍ତୁ ଏମାନେ ପଙ୍କଜ ପଥରେ ଧାଇଁ ବାଲିବଣ ସାହି ଭିତରେ ରାସ୍ତା ଉପରେ ଠେଙ୍ଗା ପଥର ବାଉଁଶ ବାଡି ପଙ୍କଜ ପିଟି ମୁଣ୍ଡ ଫଟେଇ ଦେଲେ। ଏହା
କ୍ଲିୟର ହେଲାନି କିଏ ବାଡେଇଲା କ୍ଲିୟର ହେଲାନି।
ଏଇମାନଙ୍କ ନାଁ କହିଛି
ସମସ୍ତେ ଥିଲେ
ଏତିକି ଲୋକ ଥିଲେ।
So the specific overtax act has not been attributed, but there is one witness who has specifically said kiye kota badela. So as against that, and which is consistent with the seizure list.
Yes, ma'am.
Polite. Yes.
I mean, one thing more or less direct to renew the prayer after execution, only the two eyewitnesses in the occurrence.
No.
The witness
I will reject it in case of Bhagirathi Gowda and Gauranga. Others, I don't find any of it.
Let's say the Prakash, they all are the involved in the crime and also they are also giving threatening into another FIR also laws regulations the family members of the petition.
Law will take.
And I am the only having the two kids also, the female kids. I'm not moment in the village due to the criminal activities of the petitioners and the female members also. Being terrified, I left the village also. And residing in the outside the village. On the way, they have prepared the plan and tried to kill me. And finally, they have succeeded.
53.
That was 53. 53 also.
Prabhakar Gowda.
Prabhakar, Binayak, Sahu, Gauranga Gowda,
matter record now. Both these bail applications have arisen out of the same occurrence and are were heard together. So, as such, they are being disposed of by this common order. So, the petitioners are in custody in connection with such and such case. It is alleged that all the petitioners formed an unlawful assembly and unlawful assembly and being armed with deadly weapons, they chased the deceased because of previous enmity and assaulted him, causing severe injuries on his person. Ultimately, the deceased succumbed to such injuries. Stop. See, Jyotirma Saul and counsel for the petitioner submits that the prosecution allegations are vague and non-specific. Since more than 7 persons have been alleged to have committed the offense, though more than 7 persons have are alleged to have committed the offenses, yet the evidence does not reveal the specific roles played by each of them. Sri S.K. Mishra and its State Council has opposed the prayer for bail by referring to the statement of
Biranchi
Samir Gowda.
Of one Biranchi Gowda and Samir Gowda, who have clearly stated about the role played by each of the petitioners in the alleged occurrence. Stop.
Sri Santosh Kumar Mahathi, learned counsel for the informant, also opposes the prayer for bail. He submits, that because of misappropriation of village funds by the petitioners, the deceased had protested, which ultimately led to the quarrel. Stop. There is clear evidence that all the petitioners assaulted the deceased using bamboo sticks and stones, which is evident from the injuries described in the postmortem report. Stop. He further submits the petitioners have been threatening the informant with dire consequences even after the occurrence. I have considered the rival submissions and have also gone through the case record, including the materials available in the case diary. It appears that one bamboo stick having blood stain was recovered from the possession of accused Gauranga Gowda. Insofar as accused Bhagirathi is, as per the statement of Samir Kumar Das na Samir Gowda. No. Accused Gauranga dealt blows with the bamboo stick on the head of the deceased, while accused Bhagirathi assaulted him on his head by means of stone. Stop. Though it is alleged that the other accused persons had also assaulted, yet the witnesses examined by the IO appear to have stated against them in general terms. Stop. The version of Biranchi Gowda and Sushanta Gowda, as it's heavily relied upon by the prosecution, prima facie does not inspire confidence. Inasmuch as Biranchi has himself admitted that he did not know the accused persons or the deceased by their names.
And Biranchi Debraj I do not know personally. No. Biranchi can just
Sushanta they know. Stop. Taking into consideration all the other facts, this court finds prima facie evidence available against petitioner Gauranga Gowda and Bhagirathi Gowda.
Yes.
As such, I am not inclined to allow the prayer for bail. The bail applications in respect of Gauranga Gowda and Bhagirathi Gowda stand rejected.
No, so one prayer. Only the Lordship consider the involvement of the Prabhakar Lordship. Only one accused. Lordship. He is the main conspirator who wrote it. I am coming to that. Yes. The statement of the Sushant Gowda. More name Sushant Gowda. आज आपण आगे देवा मोर मौखिक बयान है कि आम गाँव पंकज गौड़ आम सांगसाथी चलू मु पंकज को सब कथार साथ दिए आम गाँव में गोटे कमिटी अच्छी से कमिटी जन सभापति रुहे और आम गाँव आउ सब जातीय लोक से कमिटी मेम्बर रुहत प्रति 2 वर्ष कमिटी चेंज हुए 2 वर्ष पुणी नुआ कमिटी सभापति और कमिटी मेम्बर बचा हुए गला 2 वर्ष है आम गाँव कार्तिक गौड़ आम गाँव कमिटी सभापति था यही वर्ष पुणी नुआ सभापति बछा थिला गत 30/12/2022 तारिख दिन 2 प्रहर समय प्राय 2 घंटा हेब आम गाँव समस्ते आम गाँ स्कूल भितर मीटिंग रे बसिले से ही मीटिंग रे मु पंकज मिसिकी पुराना कमिटी की गला 2 वर्ष हिसाब मागिलु किंतु से किछि न कहू आम गाँव भागीरथी गौड़ तांको ग्रुप रो लोक सबु आम ऊपर को झपटी आसिले से माने कहले जे हिसाब किछि देई हेबनी कारण कार्तिक गौड़ नामक मात्र सभापति किंतु भागीरथी गौड़ सब काम बुझे यही कथा को लेकिन भागीरथी गौड़ तांको ग्रुप रो लोक माने आम सहित गाली गुलज करी आमको मारपिट कले यही कथा मध्य आमे बेगुनापड़ा फांडी थिला बेले आमे फांडी रे जणाइलु किंतु आमे काहेकि केस कलु बोली भागीरथी गौड़ और तांको ग्रुप रो लोकंकु सेमाने सुराट को डकाई मते और पंकज को मारिबा को चेष्टा कले किंतु आमे सेही भयरे आम गाँ छाड़ी आसी पंकजर मामू घर सरदापुर जाइकी रहिलु गतकाली तारीख 20/1/2023 तारीख समय प्राय 4 घंटा 30 रु 5 घंटा हेब पंकज ता मोटरसाइकेल सरदापुर बेगुनियापड़ा जाउथिला मु ओ पंकजर भाई बिरंजी गौड़ मो मोटरसाइकेल रे मध्ये बेगुनियापड़ा जाउथिलु आमे रागपुर आदर्श स्कूल पाखरे पहुंचला बेले पंकज बालीबण छक उपरे पहुंचतिला सेठारे आमको आगरू आम गाँव भागीरथी गौड़ भरत गौड़ विनायक गौड़ प्रभाकर गौड़ प्रकाश गौड़ गौरांग गौड़ और कालू गौड़ आगरू थिले सेमानक सहित आउ किछि लोक रहिला भली लागुथिला कारण से जगह टिके अधिकार गहଳି थिला सेमान पंकज को बालीबण छक पाखरे अटकाई ताकू गाली गुलज करी मारपिट करबा को धाइले यह देखि आमे मध्ये सेठारु गलु पंकज सेमानक देखि ता मोटरसाइकेल पकाई दे बालीबण साई भितर को धाइकी पळाइला किंतु एमाने पंकज पछरे धाइकी बालीबण साई भितर रास्ता ऊपर ठेंगा पत्थर बाउंस बाड़ी रे पंकज को पिटी पिटी मुंड फटेई देले यह देखि बिरंची और मु भयरे सेठारु पळाइलु कारण सेमाने हमकु मुंड फटेई देले यह देखि लसी सेमाने पंकजर मुंड फटेई देले सब धाई आगपुर आदर्श स्कूल पाखे पहुंचला बेले पंकज बालीबण छक पाखे पहुंचीला सेठारे आगरू आम गाँव भागीरथी गौड़ भरत गौड़ विनायक साहू प्रभाकर गौड़ प्रकाश गौड़ गौरांग गौड़ कालू गौड़ आगरू थिले सेमानक सहित आउ किछि लोक रहिला भली लागुथिला कारण सेही जगह टिके अधिका गहଳି थिला सेमाने पंकज को बालीबण छक पाखे अटकाई ताकू गाली गुलज करी मारपिट करबा को धाइले यह देखि आमे सेठाकू गलु पंकज सेमानकु देखि ता मोटरसाइकेल पकाई दे बालीबण साही भितर को धाइकी पळाइला किंतु एमाने पंकज पाखे धाइकी बालीबण साही भितर रास्ता ऊपर ठेंगा पत्थर बाउंस बाड़ी रे पंकज को पिटी पिटी मुंड फटाइले ही इज द मेन कॉन्स्पिरेटर लॉर्डशिप गोटे आउ छोटो छुआ भी से गाँ भी मूवमेंट कर पाले
stringent conditions, why?
No, lordship only reject the application of the Prabhakar order. Lordship may allow others only 3%.
Prabhakar किसी बहाने नहीं तो I gave you that option.
No, say कथरा से बेजी he the main conspirator. Lordship.
What does it say?
The lordship.
It doesn't at all. I mean, support your statement that he is the principal conspirator, the main conspirator.
And seizure is also so something, some article also seized from the Prabhakar. Only one accused lordship. ସମସ୍ତେ ଜାଣ ଆଉ ଗୋଟେ ଏକ୍ୟୁଜ ଲସି ନରଳିସନ ଗ୍ରୁପ ଟା ଅଧିକା ହେଲେ ବି ତ ଗାଁରେ ଚଳିପାରିବନି
ସମସ୍ତଙ୍କ ନାଁ ତ ଅଛି ସେ ସମସ୍ତେ ଗଲା ପରେ ସେ ଯୋଉ କହୁଥିଲା ତା ଦି ଶଳା ପ୍ରଭାକର ପ୍ରକାଶ
Objecting so much, so
ଆଉ ଗୋଟେ ଏକ୍ୟୁଜ ଲସି
ଚାରି ଜଣରୁ 7 ଜଣରୁ 4 ଜଣଙ୍କର ବେଲ ହବ 3 ଜଣଙ୍କର ରିଜେକ୍ଟ ହବ
ପ୍ରଭାକର ନାଁରେ କିଛି ନାହିଁ ସେ ଦି ଜଣଙ୍କର ରିଜେକ୍ଟ ମୁଁ ସ୍ପେସିଫିକାଲି କହିଦେଲି ଆଜ୍ଞା ମୁଁ ସେ ଦି ଜଣଙ୍କ ନାଁରେ ଅଛି ସେ ତ ସାକ୍ଷୀ ଦେଲେ ସାକ୍ଷୀ ଦେଲେ କଣ୍ଡିସନ ଇଜ ଡେ they will appear in the PS, my lord. Condition may be imposed.
Group ta adhikar se movement
how each day you will appear in the PS, your lordship. Condition may be imposed, my lord.
That I will definitely.
Yes.
Each day.
କିଛି ନାହିଁ ତାଙ୍କ ନାଁରେ ସ୍ପେସିଫିକ ଥାନ୍ତା your lordship not inclined.
All right. Insofar as the other petitioners are concerned, the allegations appear to be directed against the group in general. Stop. In view of the seizure of only one bamboo stick, that too from accused Gauranga. The prosecution case as laid becomes somewhat difficult to believe that all of them had jointly assaulted by means of bamboo stick. Under such circumstances, it is difficult to imagine it is difficult to make out a prima facie case against these petitioners. In such view of the matter, I am inclined to allow the prayer for bail in respect of so and so and so. Let the petitioners be released on bail on such terms and conditions as the court insisted over the matter may deem fit and proper, so and so, including the following conditions.
No. It is very difficult to consider the plight of the one widow lady worship is not moment in the women worship.
Conditions.
So, precisely, I will impose worship.
Don't worry, I will impose conditions.
Only one worship.
No. So, don't press it. Mr. Manthi, I allow you to read the entire statement. There is nothing against Prabhakar.
No, who managed to gather.
Whatever we are saying, it should be borne out from the record. Simply by making a
Surat clerkship, otherwise the crime may not be clerkship.
Including the following condition: 1, each of them shall appear before the Dagumiapada police station on every alternate day. And such fact shall be certified by the IIC to the concerned court once in a week. Next, they shall appear before the court in session over the matter, and no representation through counsel shall be allowed under any circumstances. They shall not approach, threaten, coerce, or pressurize any of prosecution to seek cancellation of the bail in case
there is no external
of the husband.
He also accused, sole accused. Custody since more than a year.
What is the allegation?
Marriage 7 years back, my lord. Allegation in general in nature.
Regularly demanding more dowry, today complaint received. You have the inquest report. You always flag the inquest report. I would like to see the inquest report in most of the cases. So produce the chemical examination report. I am granting one more opportunity.
ସେଥିରେ ସେ କହିଛନ୍ତି କିଛି ଜଣା ପଡୁନାହିଁ ବୋଲି କେବଳ ଗୋଟିଏ ଲାଲ ରଙ୍ଗର ମୋର ବୋହୂ ପ୍ରଣତି ପରିଡ଼ାକୁ ଆମ ଘରେ ଥିବା ପୋକମରା ଔଷଧ ଖାଇଦେବାରେ ଗୁରୁତର ଅବସ୍ଥାରେ ଚିକିତ୍ସା ନିମନ୍ତେ ସମ୍ ହସ୍ପିଟାଲରେ ଭର୍ତ୍ତି କଲୁ ଆଜି ଚିକିତ୍ସା ସମୟରେ ମୃତ୍ୟୁବରଣ କଲେ ଏହାର ତଦନ୍ତ କରାଯାଉ
Why did she commit suicide according to you?
He, as per my instruction, my lord, he was suffering some disease, my lord, that was unbearable, for which he taking that oshodo, jo pokomora oshodo.
No, that
is no allegation so far as the final charge sheet ta asu 306 hi asibo, and there is no injury, nothing. The husband took to her to Bhubaneswar, my lord. Thereafter she succumbed.
Bishop hospital
nahi injury hi nahi kichi.
Injury kora dakar. Injury kora dakar. Sabthare injury hobo boli mane kichi.
Final report sei jo C report ta magi thile.
What is the report?
Your lordship pass that order.
On the last occasion, the State Council was directed to produce the up-to-date case diary along with the chemical examination report positively. Considering the nature of accusations made against the petitioner, this court feels it necessary to peruse the chemical examination report. The State Council is directed to obtain the report positively by the next date. List this matter in the week commencing
6th May.
6th May.
Four days.
পরটা করো 6th May আইন করবেন যদি বেকার আগে ডেট দিবেন 13th May.
Madam, a free copy may be given.
Free copy of this order will be handed over to the State Council for compliance.
Item 69.
Last week on CD and C was called for.
CD available.
Only case diary was called for, nothing else?
Yes, case diary was called for.
Only the case diary. This is, what is the allegation, 392? 498 or 302?
Aye. And
you are the husband?
Yes, I am the husband, madam. Marriage in question has taken place in 2019.
Yes.
The decision, the person raised with 2 children. And on the prisoner suspect. That is what the allegation.
ସକାଳେ ଶୁଣିବାକୁ ପାଇଲି ଯେ ଲକ୍ଷ୍ମଣ ଭୋଇର ସ୍ତ୍ରୀ ମରିଯାଇଛି ବୋଲି ମୋର ସନ୍ଦେହ ସେ ମାରି ଦେଇଥିବା କାରଣ ସବୁବେଳେ ତାର ସ୍ତ୍ରୀକୁ ମାରାମାରି
Asphyxia due to throttling. In a pre-planned manner, he
may also keep it next week any day.
With liberty withdraw করুন
In the meantime, almost 8 to 10 witnesses examined, including informant. I'll bring a copy of the deposition.
Yes. Then comes out the petitioner requests for an adjournment in order to obtain the copies of depositions of the witnesses examined so far. Let this matter the week commencing 6th May. The copies of depositions be produced.
Yes.
As undertaken.
Yes.
Item 70.
That out of the alleged misappropriated amount of 14 crores, a sum of rupees 283 has already been deposited by the petitioner. Further, if granted some time, he would deposit the rest amount of 11 crores 49 lakhs 34,000. This was his submission, my lords. Actually, what has happened, my lords, we are a service provider and we had developed an app whereby, my lords, amounts could be paid to any company, my lords, by utilizing our app, my lords. Now, the UPI, my lords, that app we had created. Now, my lords, what happens? This informant company brings in an amount, takes in an amount of rupees 14 crores and odd. As per the FIR, 14 crores 33 lakhs, some odd amount, my lords, and has again redistributed this amount to 125 accounts. Now, the allegation has been made that I have done it. My lords, I have the QR for paying, my lords. We don't have the QR for payout. So, how can I distribute this amount? This 14 crore, the 33 lakhs, 25,923. My lords, they can utilize my app, and for a pay-in, my lords, I have the QR code. This amount comes into their account. The payout is with them. I don't have that QR identification, my lords. So how can I distribute this amount? They have distributed it and made me a scapegoat. The informant actually is the accused here.
Yes.
And last occasion, Lordship directed to take instruction how much amount he was involved. That is it, and transaction. Right? Admittedly, 14 crores, 33 lakhs, 25,000 and some odd was. And now it is 11 crores, 49,000, 34,000 is yet to be recovered. And the petitioner has totally transferred 43 lakhs, 63,700 to various accounts, to his relatives and other accounts. Malaki, this is the instruction.
43 lakhs.
It is from the iService account.
It was from the iService account, Malas. I cannot do it. Your lordship may see it.
iService.
It's a virtual wallet, by that means.
Dear lordships, have the charge sheet on record?
No.
Then we'll give a copy of that because charge sheet they have reflected everything clearly, my lords. I cannot do it. Virtual wallet, my lords, we have created for the company, but I have the paying code. Payout is not with me.
All right. Sri Milan Gangal and Senior Counsel with Mr. Mahanti appearing for the petitioner submits that the petitioner's company had floated an application using which
Pay one service.
Digital services
using which
private limited.
payments could be made to different persons.
Payment could be brought in.
Could be brought in. My lords, the virtual wallet that we had created and with the QR code, we only have the my lords identification for pay in. Wherever money is to come into this account, this company's account,
Money come to your account on what?
That's iService.
iService is a company, my lords. It has
to understand this. No, this has to be heard in detail. This has to be heard in detail.
Yes, sir.
It has to be understood.
It has to be heard in detail along with the charge sheet.
All right, then we'll simply say let the charge sheet be produced.
Got it.
Anyway, just let me write it so that he can obtain specific instructions.
Yes.
Sri Milan Gangal submits that. The petitioner's company has created an application. Otherwise called virtual wallet.
No, so pay one.
Otherwise called a virtual wallet, which into which money from different sources could be credited
to the informant's account.
There was an agreement between the informant and the petitioner.
There was an agreement between the petitioner company and the informant to such effect. It is further submitted that the petitioner company does not have the authorization nor the facility for
payout.
I'm saying that to pay out any amount. Learned State Council has obtained instructions that a sum of rupees 4363,700 was transferred by accused Karan Kumar Singh and the company from the account of iServe You Technology Private Limited, bracket informant's account. Stop. It is further stated at the bar that the final charge sheet has been filed in the meantime.
Yes.
Stop.
Final?
The
charge sheet has been filed.
Charge sheet will be filed.
We're keeping the investigation.
This court would like to see the charge sheet.
Yes.
That apart, then State Council is requested to respond to the specific submissions of Sri Kanango as referred above. Place this matter in the week commencing 6th, 13th May.
And in the meantime, we'll also may issue notice to the informant because they can
not necessarily.
whether that money transaction relating to money transaction, how much amount he's claiming at my senior stating that 2 crores rupees already given.
The informant himself is the accused. Sir, I develop an app and bring in money into X's account. X only can distribute that amount to other accounts. I can't do it.
instead of making the info, instead of he becoming the accused, I have been made a scapegoat and the buck has been passed on.
We'll do that. If necessary, we'll do that.
Yes.
How much amount he has received, what is the?
Informant obviously will try to protect itself.
Yes.
Item 73.
Deeply appreciated.
73.
CPU.
Is there?
No letter was issued because the order was passed on 22/12/23 for case right. He has solved the copy on 26/12. Therefore, letter was not issued for.
Correct. As requested by London State Council, let's this matter on in the week commencing 13th May.
Right.
Case diary be obtained as directed.
Item 74.
May I please, Honor? Well, last occasion, Lordship called for the status report, which is that flag AM matter.
The mother has been examined as PW 22. Just on host type.
Matter. This is a family dispute. It may not be 302 because the PM report is that trompa leading to asphyxia and heart failure. So, the doctor's matter is doctors are examined as PW 24
and 25.
And the reason is that the informant present petitioner is the stepbrother of the deceased. He saw that deceased he assaulted his mother. For that reason, he has bring that axe and also assaulted in the axe. It was only injuries in the eyesight of that deceased. And the mother has taken that axe and then after my lord, he was died. And it is a doctor's opinion, PW 24 is that heart failure.
The petitioner is in custody since?
Well,
where are you, since when are you in custody?
Custody valid for 2020.
18 to 2020.
4 years.
20. In connection with such and such case. The prosecution case is that the petitioner, who is the stepson of brother of the deceased, assaulted him by means of an axe, causing bleeding injury on his left eyebrow. Stop. Subsequently, the deceased died. It is submitted that none of the witnesses examined so far has supported the case of prosecution, including the informant, who was examined as PW 22. As directed, the court below has submitted a status report indicating that 31 out of 41 CS witnesses have been examined. 3 witnesses have been declined by prosecution. Stop. Further, the mother of the deceased, informant is the
PW1.
Mother of the deceased has already been examined as PW 22, whose deposition has been forwarded. Then Guti Harpal is there, wife of the deceased. Is she an eyewitness? She has not been examined. Guti Harpal.
Goody Harpal, charge sheet witness 28. And another eyewitness cited as examined as a PW2 minor. Goody Harpal says in her 161 statement that she has heard from that PW2.
All right.
Eyewitnesses matter that mother.
Including the eyewitness PW 22. Bracketed mother of the deceased. Stop. That apart, the cause of death of the deceased, as stated by the doctor, bracketed PW
24 and
24 is due to heart failure. Heart failure. Heart failure. Thus, prima facie, there is absence of the ingredients of the offence under section 302. Taking into consideration all the other facts, as also the period of detention of the petitioner in custody, I am inclined to allow the proceeding.
Obliged.
Item 75.
Yes, Mr. Pandey, you are waiting for what? Pass hours tomorrow. I will have
Tomorrow and day after tomorrow.
Today's morning list password.
Morning list was passed over. And Mr. Das, you are also waiting for which matter?
Last this list, my lord, last item.
Regular list. Regular list.
I don't think it will be possible. Let us see. Yes, Mr. Joshi.
My lord,
Item 7.
Day after.
No, tomorrow. This list is still tomorrow. Day after second appeals. So
May we accommodate at 2 o'clock, my lord? I have a
Tomorrow.
in Supreme Court because
but today also we may take it up. Will it take time?
no. Not bad.
Let us see the matter if it is necessary. Then yes, Mr. Joshi.
Yes, ma'am. Yeah, that last token recipe was pleased to call for the CD mail. The
You have the CD?
yes, yes. Date of occurrence 27/8/2023. FIR on 28/8 and the date of arrest is 28/8/2023. Allegation is the FIR in the date of occurrence.
Maji has been assaulted severely by his relative Ram Mohan Maji. You are Ram Mohan Maji?
Yes, my lord. On the date
So he received information from his wife.
yes.
Who is the eyewitness? Anybody there?
My lord, eyewitness
Manjeet Kumar Maji.
Dev Kumar Maji.
What has he said?
He says, my lord, ମୁଁ ଆମ ଗାଁର ରାମମୋହନ ମାଝୀ 2 ଜଣ ପତରା ଜଙ୍ଗଲ ବାଁଶବାଡିଆରେ ଝାଡା ଯାଇଥିଲି ସେଇ ସମୟରେ ଆମ ଗାଁର ବ୍ରିଜନାଲ ମାଝୀ ଯିଏ କି ଆମର ସମ୍ପର୍କୀୟ ଦାଦା ହେବେ ସେଇ ଜମିକି ଗଲେ ତାକୁ ଦେଖି ରାମମୋହନ ମାଝୀ ମତେ କହିଲା ବାବା ଆମର ଜମିକୁ ପାଣି କାଟୁଥିବ ଚାଲ ଯିବା ଦେଖିବା ତାପରେ ଆମେ ସେଟା ଗଲୁ ଦେଖିଲୁ ଯେ ବ୍ରିଜଲାଲ ବାବା ରାମମୋହନ ମାଝୀଙ୍କ ଜମିରୁ ପାଣି କାଟୁଥିଲା ଏହା ଦେଖି ରାମମୋହନ ମାଝୀ ବ୍ରିଜଲାଲ ବାବାଙ୍କୁ କହିଲା ତୁମେ ଆମର ଜମିରୁ କାହିଁକି ପାଣି କାଟୁଛ ଏଥିରେ 2 ଜଣ ମଧ୍ୟରେ ପାଟିତୁଣ୍ଡ ହେଲା ଓ ରାମମୋହନ ମାଝୀ ବ୍ରିଜଲାଲ ବାବା ଧରିଥିବା ବାଡିକୁ ଛଡେଇ ନେଇ ବ୍ରିଜଲାଲ ବାବାଙ୍କ ଦେହ କାନରେ ହାତରେ ପିଠିରେ ଉକ୍ତ କଞ୍ଚା ବାଡିରେ ପିଟି ପକେଇଲା ଏହା ଦେଖି ମୁଁ ଛଡେଇବାକୁ ଚେଷ୍ଟା କଲା ଭିତରେ ମତେ ମଧ୍ୟ 2-3 ବାଡି ବାଜିଲା
Renew your prayer after examination of this man. ଆଉ କଣ ସେ ତ ଡାଇରେକ୍ଟଲି କହିଛି ଡାଇରେକ୍ଟଲି କହିଛି
Lordship, keep it next week. They will say substantial progress. 11 witnesses already examined, my lord.
He has been examined.
Yes.
Then very good.
So next week any day I will produce to you.
Yes.
ଷ୍ଟାର୍ଟିଂ ରୁ କହୁନ
ସେଟା ମୂଳରୁ କହିଥିଲି ନା
I'm sorry.
Sri Joshi, learned counsel for the petitioner, requests for adjournment on the ground of obtaining the copies of depositions of the witnesses. Let's this matter next week.
6th.
Yes.
Item 76.
Item 76, your lordship has granted bail to the accused persons. I am also accused person. I am also stands in the similar footing bail. Your petitioner in
No, I remember this man was the main accused.
no. Krishna is the main accused. Your lordship has detailed observation. I am 120B. I am coming under 120B. Along with lordship, Rajiti Krishna has contacted the contact killer and Rajiti Krishna. Only basing upon confessional statement of Rajiti Krishna, these petitioners were also implicated.
Yes, what do you say?
7
I will have the CDB call because it is a in this case there are 2 cases that the Supari killer was killed in High Court and the
We demand 1 crore rupees, otherwise we will disclose this.
Supari killer was also killed by a Supari.
Killer also. Statement sheet ରେ ଅଛି ସେଇଥିରେ
Acquittal case that will be obtained, let us matter in the week commencing 6th May.
ସେ ଥିଲା ସେଥିରେ ଏତେ ଥିଲା ସେଥିରେ
So let him obtain it.
ନେକ୍ସଟ ୱିକ୍ ଥିଲା ଏଠି ଅଛି ସିଟିଟା ଅଛି ଏବେ
ବ୍ୟସ୍ତ କାହିଁ ହଉଛନ୍ତି ମର୍ଡର କେସ୍ ଟା ଗୋଟେ week ହେଇଗଲେ କଣ ଅସୁବିଧା ହେଇଯିବ? He's in custody for so long. So what 7 days more what will happen?
ସିଟିଟା ଅଛି ତ
ସେଟା ସେ ଆଣିବେ ବ୍ୟସ୍ତ କାହିଁ ହଉଛନ୍ତି?
ଏଇଥିରେ ଥିଲା ସିଟିଟା ଭିତରେ
Yes.
Item 77.
ନାଇଁ ପ୍ଲିଜ last occasion also call for the city conservatively
What is this? NDPS?
ଆଜ୍ଞା
20B, 2C, କେତେ?
75 kg.
Yes.
custody
It was kept in a Anganwadi center. Anganwadi center.
What is the case that you say?
My lord, final peer has already been submitted.
Finally, there has been some. Is there any evidence against this man?
He was appointed from the spot.
See, he had kept it in the Anganwadi center.
That abandoned Anganwadi center, he was apprehended.
So was he present there?
Yes.
What is the okay? कौन कौन ये सही ये पढ़ा भारी difficult. बंसी करते समय विशेष सूत्र भाग वाली जानने को समय माटे रंगर हाफ पैंट एवं नील रंगर ऐसे सब बना
ମୁଁ ପଢିଥିଲି ଅଙ୍ଗନବାଡି
very ଅଙ୍ଗନବାଡି ହଁ ଅଙ୍ଗନବାଡି
କେନ୍ଦ୍ର ପାଇଁ ମହଜୁଦ ହୋଇଅଛି।
ଏହି ପରିପ୍ରେକ୍ଷୀରେ ସରକାରୀ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରରେ କିଛି ବେଆଇନ ଗଞ୍ଜେଇ ଅଛି ତ ରହୁଛି ଉକ୍ତ ଖବର ପାଇ ଅଧିକାରୀ ରହୁଛି Caught at the spot.
Yes, ma'am.
ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରରେ ସରକାର ଥିଲା ଆପଣ ଚାବିକାଠି କୋଉଠୁ ଆସିବ ସେ ଲେଖିଛନ୍ତି ଯେ abandoned ବୋଲି but it is a continuing charge sheet submitted custody since 15/9 no antecedent nothing else.
The petitioner is in custody since 15/9/2023. It is alleged that the petitioner had stored 75 kgs of contraband ganja in an abandoned Anganwadi center of the village. On getting reliable information, the excise staff conducted a raid, in course of which the petitioner is alleged to have been apprehended at the spot along with the contraband stuff. It is submitted by the counsel to the petitioner that the prosecution case as laid is not believable inasmuch as the abandoned building was in a public place, being accessible to all. That apart, final PR has already been submitted, and yet trial has not commenced. Then State Council has opposed the prayer for bail by submitting that the petitioner was apprehended while in possession of the contraband stuff. Taking into consideration all the facts, and particularly the fact that trial has not commenced as yet, I'm inclined to take a lenient view. Bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 3 months.
Item 78.
please 3 months before we must take because only for 4 months I
ସମସ୍ତଙ୍କ ପାଇଁ ସମାନ ଆଜି କରିଛି 3 ମାସ ଜଣଙ୍କ ପାଇଁ ଆପଣଙ୍କ ପାଇଁ 4 ମାସ କଲେ ସେ କଣ ଭାବିବେ
before
କୋର୍ଟ ତାଙ୍କୁ ଫେଭର କରୁଛନ୍ତି କହିବେନି କୋର୍ଟ ଇଜ ଫେଭରିଂ ମିଷ୍ଟର ସାମନ୍ତର would you like to hear this thing about this court? I don't think so.
May please election before placing the matter on merit I may beg pardon to submit that the petitioner father died on 17th April. As the matter at least I could not file the interim application before the registry ballot. I am placing the same.
You can't file it later. Interim application file
at least 15 days.
When did he die?
After 4/4/2024 गत सप्ताह में.
Yes, what you say?
Government he has taken.
Interim application is filed in the court seeking interim bail on the ground that the petitioner's father has expired on 17/4/2024. Since the petitioner is required to be present at home to attend to the rights, he seeks interim bail. Planetary State Council fairly submits that considering the ground on which the prayer for interim bail has been made, the court may pass appropriate orders. Yeah. Having regard to the submissions as above and the grounds cited in the interim application, I am inclined to take a lenient view. Let the petition be released on interim bail for a period of 3 weeks. List this bail application. After 3 weeks,
20th May.
20th May. Yes. The Purvul Lakhan to IAB register. IAB filed in the court today, the SMB register. Yes.
Item 79.
Admin Secretary.
This is the matter where my learned friend was asking for the informant. A case where they were seeking government job for 59 lakhs. That is their case.
Hanuman Baba alias Chintamani Parada, who will know something. What was your submission on the last occasion?
23 of the Compact Act clearly prohibits it.
Yes, yes.
And therefore, my lord, they are using the.
You are relying upon a decision also.
Yes, two the judgments, my lord. One is Dilip Singh, 2021, and the later judgment, Ramesh Kumar.
Yes.
And I have given the.
But if there is proof of that you have taken money.
My lord, still I don't have to pay, my lord.
No, that I've seen. That
Yes.
the law is.
Yes, law.
I cannot dispute that.
No, proof may be, my lord. Well, the proof is not only proof of their having given me money. For what purpose one doesn't know.
Whatever.
Yes. And when you
say what purpose you have received money?
I really don't know. I cannot even answer that. My lord, and the Baba is the biggest person. The Baba is the player.
No, you have to pay some money. To strike a balance. That's all. If we strictly go by the law, then you are right. You are right. We generally pass such orders looking at the overall.
My lord is not enough. My lord, these, if at all even money has been paid for this purpose, never stays with them. Goes that pipeline. My lord, he is a puny fellow. He is the last of the rank. The money ultimately goes everywhere else. What that?
And he himself identifies that I am the secretary of Honorable Minister Dharmendra.
Even if I have.
Since he has taken money, he also identified that instruction. Almost among.
Hey, what is the name of the petitioner?
That is my.
What's his name?
Mahanti. Huge amount has been taken. 59 lakhs, 25,100.
Giving them government job.
Has been seized in the bottom.
Then nothing, no amount is there.
Nine. All are through account transfer.
So, and several complainants are there. 7 complainants.
Yes. And all of them, my lord, will see the complaints, my lord. They should be themselves proceeded against. I don't know why the prosecution is not filing a case against them. But they are also as much culprits as we are. Like Happy Your Life bribe giver, they are also the persons who have been wanting to utilize this system for the purpose of getting a job. Why should these people be protected, my lord? It's not a case where, my lord, money has gone. It's not a case like Sahara. It's not a case of public money. My lord is absolutely right, my lord. It's public money, and it is suppose a Tahsildar, my lord, has misappropriated. In that case, they have made a departure. This very case, and in the previous cases, Indira Bannerjee cases, absolute that you cannot use 448 and other judgment, but that you cannot make an impostor. You cannot use it as purpose. But I am only asking myself the question as an officer of the court. But why should these people who are giving money for this illegal purpose be given anything, my lord? Why?
Can you make that argument? You have received the money.
Yes, but I have received the money or it was gone elsewhere. I don't know. It is just
has been credited to your account.
yes, it may have been credited to my account, but I bowed down to everything, my lord. But the money is not even there now. My lord, obviously,
You may have parked it safely somewhere.
no. I wish he had. He can't even pay my fees, my lord, what he give me. My lord, I know the situation, no man. Fellow is not even matriculate. Full of, I mean, he thought that Baba will make him God. But Baba is the biggest scoop. And unfortunately, nothing is being proceeded against. And no criminal case against them. But why were they going, asking people?
But whatever, fact remains that 59 lakhs and odd has been.
According to them.
Yes, according.
Yes.
And there is some proof.
Yes.
Such amount being transmitted to your bank account.
Yes. My lord, all these judgments of my lord I'm citing are all judgments which have been proved. Not as if one case is there which has not been proved, my lord.
But in bail matters, sir,
all of them are bail matters.
with great respect, I must tell you that this court ultimately, even if it is sitting in a bail court, it is a court of equity.
Yes, my lord.
Court will look at
equity, my lord. I am only saying, my lord, I am only saying one thing, my lord. My lord, may kindly see to those two judgments.
I've seen on the last petition, I've seen it.
I will leave it to you, no, my lord. My lord, will kindly take that first Dilip Singh's judgment. Short judgment. Dilip Singh's judgment is short. I've given
private disputes cannot be.
No, my lord. This Dilip Singh says in excess held criminal court exercising jurisdiction for grant of bail or anticipate bail is not expected to be a recovery agent to realize the dues of the complainant, and that too before trial. My lord, this is not a case where they file a case for recovery. Let them file a suit for recovery. I would understand their bona fides. My lord gave that order also in a case of mine, my lord, the doctor who was 5 years in custody, my lord. Nothing recoverable. And that was more money than this, my lord. That Reshma College person, my lord, granted bail. Because of the fact, my lord, even if he tries to sell himself also, my lord, there is no money to pay. My lord, therefore he will.
Where has the money gone?
My lord,
it has gone from your account. So you must say where has it gone?
Well, that also
that money trail that would be important for the prosecution to find out.
My lord, that they should find out, my lord.
You say it has gone to your account. I will not accept this, sir. I will not accept this argument, sir. It has gone to your account. You have parked it. So you must say where it has gone.
My lord,
your company, your bank account is left with 438. 1,000.
Yes, my lord.
Three accounts.
My lord, I bow down to all these. I
need an answer. I need an answer.
I cannot be that man doesn't even. How can I talk with him in his custody, my lord?
No, you can. You always. You means he can. But what is the money trail that you have found? I fully accept what you are saying.
Well, kindly see the sections. The sections also, my lord. How long?
He has 14 numbers of account and only 3 numbers account where
these accounts to which the amount was transmitted or transferred rather. You have given 7 accounts, 7 complainants, and they have deposited different accounts. And total comes to 59 lakhs according to you.
Yes.
Total comes to 59. What happened to that account? So the bank can easily say to which account those amount.
Well, it can be ascertained.
So the money trail you have to find out.
But he has admittedly taken the money.
All right.
By cheating that he is the private secretary of Hon'Ble Minister.
So even if he has cheated, have you gone through this Dilip Singh judgment? The court is not going to become a recovery agent. It's a private dispute. It's not an economic offense. It is not an economic offense.
Yes.
Like we pointed out in another case very recently. I think Mr. Mishra or who you were arguing. Very recently we said it's a private dispute between two individuals.
And in fact, the next judgment specifically says that supposing it is public money, it should be recovered.
Public?
And he has cheated many persons. Not only this a particular person.
Yes. Anything you would like to say? I'll close the other. Yes. Anything?
My lord, as far as the prima facie is concerned, my lord senior denies the prima facie that 420 is not made out. So here is a case when the money received by the accused petitioner is proved under the 3 accounts. How can they deny?
Where did I make that submission? I don't remember.
No.
I'm saying 420 case of 420.
I am submitting 3 to 4 lines. Number 1, that I must say this case has prima facie. The matter at trial cannot be questioned at the bail. my Lord and Senior admits that money received and becoming the author of the case now in pleadings, he cannot be author of the case. His pleading shows that he is author of the case.
I cannot follow. What is the meaning of author of the case?
Author माने मु जहाँ कहूँ से हबको दिया जाऊ बोली अनुरोध करूँ मेरे कौन ना I received money I received money से money shoot करंतु मु जहाँ कहूँ सेटा एक्सरसाइज हो तो मु कहूँ जे से एभली प्रेस्क्राइब करि परिबेनी ना एभली कथा कहि परिबेनी बिकॉज़ इट इज अ बेल से चाहउछंती one type quashing माने 420 is not made out as far as Indian Contract Act is concerned by reciting a judgment, two judgments by Honorable Supreme Court. What section 23 says? Consideration. The word consideration can be defined very large. Doba noba, but value thai. Here is a case, a person taking money, giving assurance that I will provide job. I will provide job.
So it is a valid contract. पैसे देगी चाकरी गोटो करे दो और valid contract.
My lord. Though it is a void contract, but it is not coming under civil law. It is my submission. It is purely coming under criminal law and purely coming under the ambit of 420. As far as 419 and 420 is concerned, another two sections 465 and 68 by personating and impersonating. Himself, I earlier said 3 names. I earlier said he has furnished 2 to 3 to 4 I-cards. And personating is I am the secretary someone. What it proves? So money gone to the account of the petitioner is proved. My Lord and Senior deliberately saying by citing only 2 judgments that it is coming under Indian Contract Act, so they can file money suit, and here is I may be released. So outrightly, I may not accept the submission of my Lord and Seniors. It is not coming under any of the act of Indian Contract Act.
Correct. That's all. Anything else? Yes, sir. Anything else?
One sentence. As far as their petition is concerned, what this says at para 3.4, the petitioner is a labor contractor. Have they filed any document to prove that I am the labor contractor? For that reason, I said before the court under submission, they cannot be the author. Mu jaha kochi se ho. Se kochi ni contractor kichi dau nahanti. Mu paisa nei. E dharanor submission I may not. Informant support. Informant paid. Yes, just reciting 2 minutes. I will take the from a judgment by this court in Akash Pathak case. What this court said, our Honorable High Court, we are not reciting anything. In Akash Pathak case at para 15, economic offences constitute a class effect and need to be visited with a different approach in the matter of bail.
This is Jagannath Reddy. I'm quoting Jagannath Reddy.
Yes.
Yes, Jagannath Reddy. You have quoted it.
Yes, sir. The economic offences having deep-rooted conspiracies and involving huge loss of public funds.
So according to you, this is an economic offence. According to you.
Whatever this judgment is concerned, as far I gone entire judgment, 2 to 3 aspects coming under economic offences, and thereafter court have good observation. We have to learn by this court observation. We have to learn. The very term unemployment sounds like a death knell for the future of the youth of this nation. When an educated youth carrying certificate of boards and universities drenches in rain of sorrows for non-availability of any suitable job for him and unable to show his tears to anyone, even though he is crying inwardly, feeling pain in his haunting heart and tries to hide sign of sadness instead of providing him an umbrella for weathering storms of life and playing supportive role or let it overcome depression. if someone on the pretext of providing job exploits the youth, someone exploits the youth and dupes him in his money, arranged with most difficulty and makes him falling prey to temptation of lucrative jobs, it is cheating of highest order. All right. So we are learning, sir. All right.
Hearing concluded, judgment reserved. Parties may file the note of submissions if and memo of citations, if any, within 3 days.
I have given the list of citations already to my lord, a compilation.
All right. I may be allowed 3 days. I will. Yes, yes.
And my lord, I want to just add, since my lord should add, I just want to add one sentence and leave it to your lordship, my lord. 420 postulates that I must have induced him. Where is that induction? He so volunteers to come and pay me.
All right. Item get it?
Supplementary list item now 25.
25.
My lord.
Only one matter. Yes, what is this?
Well, I have sought for interim bail for undertaking an operation for a condition that I am suffering from, that is varicose veins in the right leg.
If I remember correctly, he had refused.
Declined. Say operation. I said that unwilling will lekha declined no willingness will lekha.
Not willing.
Not
You interpret it. I will leave it to you to interpret.
बाहर कोई operation करी बोले वो कहली
ये कितना चलो नले नहीं मतलब.
Yeah, this condition was existing even when your lordship granted him.
I have given him that
truth can.
I have given him sufficient indulgence.
Yes,
you will agree with it.
Yes, I won't deny that. This is an operation which requires.
Let him come. Let a date be fixed. Let him come up with a specific case that I will grant him that.
Unless he is taken out and unless he.
When he was taken out, he says that I am not inclined. Yeah, last time I had seen the document. Yes, I had seen the document.
I consider that document is there. What the doctor has written, that he is unwilling.
If he is unwilling now, I leave him.
What reason, lords? That she was brought straight from the jail to the hospital, my lords, without any family members or anybody. For that purpose, my lords, he said that immediately I am not.
This is an explanation which is being added, Mr. Ponda. He does not say so. It is not borne out from the record. How can the court imagine? You are giving an explanation, all right. But then let us find out a date on which he will be operated. I will definitely grant.
Who will fix a date? Will in jail?
Yes. He will be examined by the jail doctor or whoever. Let him be produced before the
jail doctor will not be in a position to fix a date for operation.
No. SCB Medical College Hospital, he is not willing to be operated upon.
But the man who is a resident of Raurkela, they bring him to SCB. The doctor
let him be produced before the Raurkela Hospital then.
Yes. There the facilities are not there.
So where the facilities are available?
There are private hospitals also.
Well, SCB Medical College, why will he not be operated upon, you tell me?
At my lordship, your lordship knows, my lordship, everybody is not.
But any root canal he also denied in government hospital.
That I have granted sufficient indulgence. That is besides the point. That is already gone. So here, I am also, he is suffering from that varicose veins. Varicose veins needs specialized surgery.
Yes.
So you come up with a
with surgery, my lords. It is a condition which recurs.
No, that's all right. I don't know, but last occasion,
this man is a living example of that.
No, Mr. Panda, last time when he applied for repeated interim bail and it was granted.
Yes.
You had come up with a definite case that he is to be operated on such and such date. If I remember correctly, that he was given sitting on from such and such date and such and such time. Here there is no such thing. You come up with a case, I will consider definitely.
Then my lordship may admit, let him go for a checkup next whenever possible and then let it be done.
So let him come up with a definite case. I will definitely consider. I have requested by release this matter in the week commencing next week.
Lords, from morning will they take me with a week to a sick or whatever.
Then I will pass that order.
How is it possible that on my prayer they will take?
No, I'll pass that on. Sri, the Lagos State Council has produced an OPD card in respect of the petitioner issued by the SCB Medical College, where it is mentioned that at present, the patient is not willing for surgery. Stop. See the straight from the jail. Stop. He obviously needs the presence of his family members. Stop. Considering the submissions as above, this court, should I direct him to be produced before the SCB or?
Your lordship.
So this court directs the jail authorities to produce the petitioner before the SCB Medical College Hospital with due notice to his family members, plus to fix a date of surgery. Let the same be intimated to the court by the State Council, whereupon the prayer for an interim bail shall be considered. List this matter, the week commencing 6th May.
As well.
6th May. The order be complied with in the meantime. Yes.
Beg pardon, item
Copy
38.
copy of this order be handed over to the State Council. Yes.
38, my lord, weekly passover, my lord. On that day, my learned senior OPID counsel was not there. He has to take instruction regarding the.
Tomorrow we'll take it up.
After my non-fair, and about the affidavit, I have also handed over to the IO, 6-7 days time. So, insurance.
Item 38.
38.
Item
38. Next week as paid for.
Okay.
Okay.